Good morning, ladies and gentlemen. The Asia Pacific Private International Law Summit will commence shortly, so please be seated. On a gentle reminder, please kindly switch your mobile phones or any electronic devices to silent mode. The summit will be conducted in English with separate channels for simultaneous interpretation in Cantonese and Putonghua. You can pick up a simultaneous interpretation headset at the entrance of this room. Please tune to channel 1 for English, channel 2 for Cantonese, and channel 3 for Putonghua. For online participants, you may choose the preferred language by clicking the language button on the sidebar. There will be 4 panel sessions today. A Q&A session will be located at the end of each section. If you have any questions, please write them down on question slips and pass them to our crew members. You may also scan the QR code, which will be shown during each section for Q&A, and type your questions via the link. If you need any assistance, please raise your hand and our crew member will provide assistance accordingly. For online participants, you can simply type your questions directly into the chat box and we will address them together at the Q&A section. 咁多位嘉賓，大家早晨。香港法律週2022亞太國際司法峰會即將開始，請咁多位嘉賓盡快就座。同時請大家將你哋嘅手提電話調校至靜音模式。今日我哋嘅論壇將會以英語進行，並設有粵語以及普通話嘅即時傳譯服務。大家可以喺門口嘅位置領取即時傳譯嘅耳機。頻道1係英語，頻道2係粵語，頻道3係普通話。線上嘅參加者，你可以點擊直播框旁邊語言嗰個按鈕去選擇收聽你嘅語言。今日一共有4場專題討論，每一場嘅專題討論結束之後都會有答問環節。如果你有任何問題，可以將你嘅問題寫低，然後交俾我哋嘅工作人員。同時，你亦都可以喺到時會顯示嘅二維碼掃描嗰二維碼，將你嘅問題直接輸入去到我哋嘅問答系統入面就得㗎啦。如果你需要任何協助，大家可以隨便舉手，我哋嘅工作人員將會為你解答。線上嘅參加者，你亦都可以直接將你嘅問題輸入至對話框入面就得㗎啦。我哋今日嘅嘉賓將會喺問答環節嗰度回答咁多位嘅問題，多謝合作。尊敬的各位來賓，大家早上好。香港法律週2022亞太國際司法峰會即將進行，請大家盡快就座，同時把手機調校至靜音模式。今天的論壇將會以英語進行，並設有粵語及普通話的即時傳譯服務。您可以在門口領取即時傳譯耳機，頻道1為英語，頻道2為粵語，頻道3為普通話。線上的與會者，請點擊直播框旁邊的語言按鈕去選擇收聽的語言。今天一共有4場專題討論，每一場結束後都設有答問環節。如果您有任何問題，您可以把問題寫下，然後交給我們的工作人員。同時，你也可以掃描待會兒出現的二維碼，直接把您的問題輸入到我們的問答系統裡面就可以了。如果需要任何協助，請舉手，我們的工作人員將會為你解答。線上的與會者，請直接將你們的問題輸入至對話框便可。我們的嘉賓將會在問答環節回答各位的問題。謝謝合作。 The Honorable John Casey Lee, the Chief Executive of the Hong Kong Special Administrative Region, Commissioner Liu Guangyuan, Commissioner of the Ministry of Foreign Affairs of the People's Republic of China in the Hong Kong Special Administrative Region, Secretary for Justice, Mr. Paul T.K. Lam, SBS SCJP, Professor Ignacio Tirado, Dr. Christophe Benasconi, representatives of international organizations, councils generals, distinguished guests, ladies and gentlemen, good morning. Welcome to the first event of the Hong Kong Legal Week 2022, the inaugural Asia-Pacific Private International Law Summit co-organized by the Department of Justice of the Hong Kong SAR of the People's Republic of China and the International Institute for the Unification of Private Law, UNIDROIT. So a very warm welcome to everyone participating in today's summit, both in person and also online. My name is Vinci, the MC for today. So to kick off today's summit, opening remarks will be delivered by the Chief Executive, followed by Commissioner Liu, and then by Professor Ignacio Tirado. May we first present to you the welcoming remarks of the Chief Executive. Ladies and gentlemen, let's take a look.
Commissioner Liu Guangyuan, Professor Ignacio Tirado, Dr. Christophe Benasconi, representatives of international organizations, consuls general, distinguished guests, ladies and gentlemen. It is my pleasure to welcome all of you in person and online to the Asia-Pacific Private International Law Summit today. The summit marks the opening of the Hong Kong Legal Week 2022 in celebration of the 25th anniversary of the establishment of the Hong Kong Special Administrative Region. As we celebrate our return to the motherland, we also commemorate the successful implementation of one country, two systems principle for the past 25 years. Under the one country, two systems principle, Hong Kong has continued to thrive as the gateway connecting our country to the rest of the world. As stated by President Xi Jinping in his important speech on July the 1st, we must adhere to this principle in the long run. President Xi has also made it crystal clear that the central government fully supports Hong Kong to maintain the common law system. Our legal system is underpinned by the rule of law, which is a core value of our society and the cornerstone of Hong Kong's success. The basic law not only guarantees the continuation of the common law system, but also ensures the judiciary's independent judicial power, including that of final adjudication. Also enshrined in the Basic Law is the protection of various fundamental rights and freedoms in accordance with the law, manifesting the strong foundation of the rule of law tradition. Our strong rule of law tradition will continue to flourish. I'm pleased to share with you a great development in this field. With the strong support of our country, the International Organization for Mediation Preparatory Office will be established in Hong Kong. The International Organization for Mediation will be an international intergovernmental organization that will provide friendly, flexible, economical, and efficient mediation services for international disputes. Next year, the office will commence and organize the negotiation of the relevant international convention and the preparatory work to establish the organization. The great decision to choose Hong Kong SAR as the location for this preparatory office signifies a vote of confidence by the relevant states in placing their trust in Hong Kong's strength as an international legal and disputes resolution services center in the Asia-Pacific region. Ladies and gentlemen, as mentioned in my policy address delivered last month, the Hong Kong Legal Week 2022 is the starting point to showcase to the international community two important aspects of our legal system. First, the strength of Hong Kong's rule of law, and second, our diversified legal and dispute resolution services under this system. Throughout this week, we are privileged to be joined by eminent experts, practitioners, government officials, academics, and professionals of different sectors coming from around the globe. Our distinguished speakers will share their insights on a wide spectrum of issues, including facilitating access to justice through international instruments and diversified dispute resolution mechanisms, law tech developments relevant to the Belt and Road Initiative, and promoting the rule of law for sustainability, to name but a few. Today's summit, therefore, marks a very good start of our initiatives. I am honored that the summit has gathered a prominent participation of guests and speakers from renowned international organizations and leading international experts of relevant areas. Your participation in the Hong Kong Legal Week signifies your vote of confidence in Hong Kong, our rule of law, and our strength under the principle of one country, two systems. Ladies and gentlemen, last week, I welcomed top financiers around the globe in Hong Kong at our Global Financial Leaders Investment Summit. This week, we'll welcome distinguished legal professions to the Hong Kong Legal Week. Our message is clear. Hong Kong is on stage again. Our talents are ready to offer the world the best of their professional services in commercial law, arbitration, and IP trading, as well as in finance, shipping, and technology. Savor the chance to experience the smartest of Hong Kong while you are here. On this note, I wish you all a fruitful summit and a great legal week ahead. Thank you.
Thank you. Thank you. A big round of applause to thank the Chief Executive. Now, it is my pleasure to invite Commissioner Liu Guangyuan, Commissioner of the Ministry of Foreign Affairs of the People's Republic of China in the Hong Kong Special Administrative Region, onto the stage to deliver his welcoming remarks. Commissioner Liu, please.
Honorable Chief Executive John Lee, Secretary General Professor Tirado, Justice Secretary Mr. Lam, distinguished guests, friends and colleagues, ladies and gentlemen, it's very meaningful for us to gather in Hong Kong, a global metropolis where East meets West, to exchange views on developments and opportunities in the field of international law. On behalf of the Commissioner's Office of the Chinese Foreign Ministry in Hong Kong, I'd like to extend warm congratulations on the opening of the Hong Kong Legal Week 2022 and the inaugural Asia-Pacific Private International Law Summit. The rule of law is a cornerstone of Hong Kong's prosperity and stability, and the practice of one country, two systems has always been based on the rule of law over the past decades. The year 2022 has witnessed the 25th anniversary of Hong Kong's return to the motherland and the 20th National Congress of the Communist Party of China. On both occasions, President Xi Jinping reviewed historical achievements of one country, two systems, especially Hong Kong's transition from chaos to stability. He also elaborated on new philosophies for upholding and improving one country, two systems, charting the course for Hong Kong's future. Over the past quarter century, the rule of law has played a big role in the success of one country, two systems. Going forward, how can the rule of law better ensure the success of the policy? Today, I wish to share my views about this topic. First, the rule of law could consolidate the institutional foundation of one country, two systems. One country, two systems marked a new era of Hong Kong's rule of law. 25 years ago, Hong Kong's pre-existing laws, including its common law, were incorporated into its constitutional order, which is based on China's constitution and Hong Kong's basic law. Today, to safeguard the foundation of Hong Kong's rule of law, we must, first and foremost, protect the authority of the Constitution and the basic law. As a Chinese saying goes, a society could not be well governed without its law keeping updated. It's true to Hong Kong. 25 years ago, one country, two systems was just a concept. But to date, it has been successful practice for 25 years. We made it possible by never forgetting our original aspiration and never stopping improving the policy as needed. We must carry forward this spirit and continue to improve Hong Kong's legal systems and institutional mechanisms. Only by doing so can one country, two systems grow with new vigor and vitality. Second, the rule of law could help ensure Hong Kong's good governance. Good systems underpin sound governance. It is a truth testified by human history. Hong Kong's transition from chaos to stability has once again proved that law-based governance is the most reliable way of governance. The rule of law has helped and will continue to help Hong Kong enjoy a long-term prosperity and stability. At present, Hong Kong's economic and social development is faced with some deep-seated issues, and growing the economy and improving people's livelihood is not an easy task. To build Hong Kong a better place, the rule of law has an indispensable role to play. The importance of the rule of law must never be underestimated, so that a strong legal energy could always be released to enhance Hong Kong's strengths and address Hong Kong's difficulties. Third, the rule of law could strengthen the unique status and advantages of Hong Kong. Hong Kong has a significant legal advantages. For example, it is compatible with both Chinese and foreign legal rules. It has a wealth of legal professionals and a well-developed legal service industry. With the strong support of the motherland and close connection with the world, Hong Kong has long been hailed as a super connector for legal exchanges between different countries and jurisdictions. Over the years, thanks to the supportive policy of the country, more and more international legal organizations have set up offices in Hong Kong, and a growing number of Hong Kong youth have gained opportunities to work in agencies such as the International Institute for the Unification of Private Law and the Hague Conference on Private International Law. Also, legal experts from Hong Kong are making their distinctive contributions to global affairs by negotiating international conventions as a member of the Chinese delegations. As the motherland expands its support to Hong Kong, Hong Kong's legal competitiveness will continue to be sharpened, and its well-established legal reputation further cemented. Ladies and gentlemen, as we speak, changes of the world, of our times, and of history are unfolding in ways like never before. The instability and uncertainty facing the international community have markedly increased. And unilateral and protectionist acts of long-arm jurisdiction, barrier setting, decoupling, and chains cutting have shown no sign of decrease. This backlash against globalization violates the legal spirit and undermines international law and global order. Facing global challenges, no country can stay unaffected. The only way out is all countries standing in solidarity. As a responsible member of the international community, China will work with other countries to make efforts in the following aspects. First, upholding the authority of international law. China adheres to the international rule of law, which is a solemn choice and promise made by Chinese people based on our experience over the past century. As a defender of the UN Charter and international law, China has been upholding and using the rule of law to guard against hegemony and power politics and protect fairness and justice. The ups and downs in international relations have proved time and again that abiding by international law brings benefits to humanity, while dividing it from it causes disaster. So we must champion the international rule of law, coordinate and regulate state-to-state relations through systems and rules, ensure equal and uniform application of international law to all, and safeguard and practice true multilateralism. Second, updating rules for global governance. International rules should be accepted by countries around the world, not decided by a few. China believes that water affairs should be handled through extensive consultation to better reflect the legitimate concerns and needs of most countries, especially developing countries. Faced with questions of our times, what has happened to the world, and how should we respond? President Xi Jinping offered China's answers by putting forward a series of new proposals, including the Global Development Initiative and the Global Security Initiative. China is ready to work with all countries to implement the initiative for common development and common security. Third, promoting compatibility of laws between countries. Globalization is a trend of our times, along which the new industrial and supply chains are gradually taking shape. The new business forms, such as the digital economy and artificial intelligence, keep emerging. However, there are still deficiencies in the legal norms of different countries and setbacks for legal convergence between countries. We should, on one hand, set up rules and regulations to improve governance in the new sectors, and on the other hand, tear down fences and barriers to build on unimpeded rules highways. We must work together to create an open, fair, a non-discriminatory legal environment for technical innovation, and use the rule of law as a golden key to unleash the positive effects of globalization and achieve shared development. Ladies and gentlemen, the 20th National Congress of the Communist Party of China maps out a blueprint for advancing great rejuvenation of the Chinese nation through Chinese modernization. It also points out that the right direction for global development is to build a community with a shared future for human progress and harmony. Long and difficult as the journey is, sustained actions will take us to the destination. China will join hands with the international community to promote humanity's shared values of peace, development, fairness, justice, democracy, and freedom, to oppose all kinds of interference and challenges, and advance the international rule of law. Together, we should create a better future where international fairness and justice lights up humanity's way forward. Thank you so much.
Thank you. Thank you, Commissioner Liu. Please be seated. Today marks the official opening of the Hong Kong Legal Week 2022, and we are so honored to house a prominent law professionals and experts in joining us at today's summit. And now, it's the inaugural of the Asia-Pacific Private International Law Summit, and we are honored to invite our co-organizer onto the stage for the opening ceremony. Now, we would like to invite Professor Ignacio Tirado, Secretary General of the International Institute for the Unification of Private Law, UNIDROIT, to deliver his welcoming speech. Professor Tirado, please.
Good morning, everyone. With a special word of gratitude to Chief Justice Lee for his words at the beginning. Excellency Commissioner Liu, Excellency Secretary for Justice Lam, Excellency Secretary General and friend Christophe Bernasconi. Thank you. My first words of gratitude would like to go to all of you who have organized this special event. It was 3 years ago, almost, that I was here for the last time. After having been here several times, this is a place very dear to my heart, and a place I admire very much. And being back here after that time feels like a victory of the people, and like the victory for humankind in a way, because it means we've gone back to ordinary life. We've been able to overcome one of the most important challenges that the world has faced in generations. So being back just feels excellent. The fact that we are here featuring also as co-organized, co-sponsors, and as part of the central point of this very important legal week, especially relevant for us. We deem Hong Kong as one of the world's most important legal hubs, and it is our honor and our pleasure to be featuring here with all of you for this very important event. After COVID, the world and the world's economy stopped, and one of the things that's most necessary to take back the activity, to go back to the world that we knew, to go back to international exchanges, to freedom, to economic growth, is legal certainty. And that is what UNIDROIT is all about, in a way. UNIDROIT, with its sister organizations and other transnational law organizations, are about harmonizing private law, are about modernizing private law, and that sets the basis for economic growth because by enhancing legal certainty, it allows the market to invest again and to go back to growth. So on the one hand, we have the strength of Hong Kong's institutional position as a legal hub and transnational law organizations modernizing instruments which couple very well and make up for an equation of certain success. It also speaks very highly of the fact that we've been invited of the very good relationship, excellent, I'd say, that technical organizations such as UNIDROIT holds with Hong Kong's special administrative region of the People's Republic of China, and also the very good relationship that we hold with the MOFCOM at the People's Republic of China through our memorandum of understandings and exchanges. We think that partnering up together in the development of good, modernized, technical trade norms is essential for growth and is good for everyone. And we're very happy about this partnership. Our work is, and I will not be too long about the work that we are conducting now, but I'd like to highlight 5 pillars of our work, many of which will be the subject of discussion this week. One of them is access to credit. Credit is it's the blood of commerce and is therefore what's necessary for growth. And some of UNIDROIT's instruments in access to credit are absolutely key. I cannot but mention the Cape Town Convention, which allows for access to credit for the use in different legal ways of high-value equipment, of which I'd like to highlight perhaps at this stage 3 of its protocols. The aircraft protocol, which has been so important for the aircraft industry and which has allowed the industry to, in a way, survive through the single most important economic crisis the sector has probably ever had, because planes were on the ground for almost 2 years. When has that happened, globally speaking? However, it has endured, and not without difficulties. It is starting to pick up again, and in a good way. This is in part because of instruments like the Cape Town Convention, which provide legal certainty to operators in the market. Its resilience through the COVID crisis has been outstanding. I'd like to also mention our rail protocol, which is about to come into force, which we believe can be a key instrument also in the development of the Belt and Road Initiative going forward. If you will indulge me, I'd like to mention our toddler, because it was 3 years ago that it was born and it's no longer a baby, it's now a toddler, although COVID didn't help in its development at the beginning. Our MAC protocol, mining, agriculture and construction equipment instrument, which should be a game changer for growth, especially in developing economies where agricultural businesses are of the essence. A second pillar would be UNIDROIT's work in the fostering of economic exchanges. And for that, I can only mention, because of time reasons, but I'd like to underline UNIDROIT's principles on international commercial contracts, which are approaching its 30th anniversary. These principles have proven essential in dispute resolution around the world as a restatement of contract law, globally speaking. They have proved essential also in helping modernize legislations. There are a number of legislations around the world which have been shaped in part following the principles, and amongst which countries of the importance of the People's Republic of China in part of its new reform in the civil code, or France, for example, or other countries around the world. And we are now together partnering with the International Chamber of Commerce, about to start new work on investment contracts, the private part of investment contracts, in the light of the principles of UNIDROIT, and also the standard clauses of the ICC. Third pillar, of which Hong Kong is very much advanced, is our work on law and technology, and our we believe, very important project on digital assets and private law, about which some time will be devoted this week as well. The interest has been so large in our project that we've had to create an alternative body for receiving feedback from countries and regions of the world, a steering committee, adding to our working group and to it our subgroups. The drafting of this set of principles has attracted so much attention that we are having meetings of subgroups with as many participants as a normal diplomatic conference would take, which is, we believe, a good sign of where we are headed. And this is only the beginning of our work on law and technology. Fourth pillar, who can't leave outside? Not us. This is going to be one of the focal points of our future work, sustainable development. Our instruments are, of course, fully focused on sustainable development, but we are starting now new projects on sustainable development, including and especially with a focus on how contracts and the both horizontal and vertical relationships of the supply chain can achieve sustainable development in all of these different manifestations. So we have our project together with FAO and IFAD on legal structures of agricultural enterprises and other instruments that we will continue to develop moving forward. One final word, fifth, financial stability. We will be speaking about this today later on. We have our project on bank insolvency with a focus on small and medium-sized banks, together with the institutions of Basel, the Bank of International Settlements. We have the IMF, the World Bank, and most of the central banks participating with us. We have the Central Bank of China. We have the Financial Authority of Hong Kong. We have the Central Bank, the European Central Bank, Bank of England, the Federal Insurance Corporation of the United States. So we have the main actors in the field getting together in a venue which is quite unusual, because these type of instruments normally take place exclusively in the context of the Basel institutions. But because this type of work has such a strong link with private law, there was an agreement to share the project together with the Basel institution. So this is also ongoing work, and it completes for a time being our fifth pillar of the work that we're going to be going over this week. So it only remains for me to thank you all very much, to say that I am extremely pleased, we are the UNITROA team extremely pleased to be here and grateful for the opportunity, and that we are very much looking forward to an excellent week of discussion and technical work. Thank you very much.
Thank you. Thank you so much, Professor Tirado. Please be seated. We do look forward to an exciting week together with all of you. We will now begin today's summit with our first panel session of the day. So we would like to invite our moderator and also speakers, please kindly proceed onto the stage for this first panel session of the day. The first panel session is entitled Facilitating Access to Credit in the Asia-Pacific Region, International Instruments Supporting Asset-Based Financing, Supply Chain Finance and Leasing. We are honored to have Dr. Christophe Bernasconi, Secretary General of the Hague Conference on Private International Law, HCCH, as our moderator to kickstart our panel discussion today. And joining Dr. Bernasconi on stage, we have 3 speakers physically and 1 speaker online. They are Professor Anna Veneziano, Deputy Secretary General of UNITROA, Mr. Brady Watson, Professor Hara, and Mr. Jin joining us online. Just a gentle reminder to everyone, today we will have 4 panel discussions. Please be seated, feel free. Our moderator and speakers, please feel free to enjoy yourself. And we will have 4 panel discussions for today, and we will have a Q&A section at the end of each panel discussion. So if you have any questions for our moderator and also speakers, do feel free to write down your questions on the question slips and pass them to our crew members. You may also scan the QR code for Q&A and also type your questions via the link. If you need any assistance, feel free to reach out to our crew members. For online participants, you can simply type your questions directly into the chat box, and our speakers and moderator will address them at the end of the section. Without further ado, I can see our moderator, Dr. Berlusconi, is ready. So over to you, Dr. Berlusconi, please. A big round of applause to our moderator and speakers.
Distinguished guests, ladies and gentlemen, welcome and good morning. My name is Christoph Berlusconi, and I'm very pleased to moderate the first session of the Asia-Pacific Private International Law Summit, kicking off Hong Kong Legal Week. This session focuses on facilitating access to credit, and what better venue for us to have this discussion than in the International Financial Center that Hong Kong is. And can I just echo the words of Secretary General Tirado? It really feels wonderful and great to be back in Hong Kong and to see so many friends again. I begin by thanking Chief Executive Lee and Commissioner Liu for their opening remarks, which set the stage for this important event by providing us with the context of why this conversation is both timely and necessary. And they did stress, of course, the importance of the principle of rule of law, both within the one country, two systems principle, but also as a global, indispensable rule for society and global governance. Allow me also to congratulate Professor Ignacio Tirado, Secretary General of UNIDROIT, and my long-time close companion in our efforts towards the unification of law and good friend also. Thank you very much. And his opening remarks also very much rightly focused on the importance of law as means to support economic growth, and access to credit, of course, is very much part of that. As Secretary General of the Hague Conference on Private and National Law, the HCCH allow me to reiterate that our mandate and expertise focuses on the progressive unification of the rules of private international law. Today's world sees an ever-increasing number of constant cross-border interactions between individuals and businesses. Commercial transactions, relationships between actors, resolution of disputes that invariably arise, these are increasingly taking place across multiple countries. These activities require a high degree of legal certainty and predictability to thrive. However, when taking place across borders, legal systems must be bridged to make sure that it is clear to stakeholders and parties which authority has jurisdiction, which law is applicable, how decisions are being recognized and enforced, and what cooperation mechanisms are available to overcome these often very practical challenges of cross-border judicial or administrative procedures. This forms the core of the HCCH's work, the pillars of private international law. For nearly 130 years, the HCCH's mission has been to bridge legal systems and frameworks by providing internationally agreed solutions developed through the negotiation, adoption, and operation of international treaties, the HCCH conventions, to which states may then become contracting parties, and soft law instruments which may guide states in developing their own legislative solutions. These treaties and instruments provide the framework of private international law that, until private law in the many jurisdictions around the world is completely harmonized, ensures legal certainty that is the bedrock of business efficacy. Our instruments are particularly focused on resolving cross-border questions, including jurisdiction, applicable law, and recognition and enforcement of decisions. We work actively in the fields of commercial, digital, and financial law and transnational litigation, in addition, of course, also to family law, acting as a respected forum for consensus-based, effective multilateralism bringing nations together to cooperate in the joint development of mutually beneficial legal frameworks in private international law. In carrying out this work, we follow closely the developments of our two sister organizations, UNCITRAL and UNIDROIT, with the secretariats of all three organizations coordinating regularly. I recently had the opportunity to discuss key initiatives, including in international finance and trade, with the heads of our sister organizations, my dear friend Ignacio, and also Anna Joubin-Bret, Secretary of UNCITRAL. The three of us opened the recent HCCH conference on commercial, digital, and financial law, Codify, recently in September. Our organizations form a tripartite of sister organizations, each of which makes distinct contributions to substantive private law and private international law in line with our respective mandates, while closely following and contributing to complementary projects. In our discussion at the Codify conference, we recounted our organization's long tradition of collaboration, and I'm glad to say reiterated our commitment to work hand in hand on commercial and financial law topics. Together, our organizations are guardians of an impressive body of tools which should be quite familiar to this audience. Let me just mention our tripartite legal guide to uniform legal instruments in the area of international commercial contracts, UNCITRAL's CISG and model laws on international commercial arbitration, and of course UNIDROIT's instruments that are the subject of this panel. On our side, the ACCH Securities Convention and the principles on choice of law in international commercial contracts. I expect that the future is bright for expanded cooperation, dialogue, and sharing of ideas. In this context, I'm pleased and honored for the opportunity to moderate this panel focused on international financing and leasing, highlighting the UNIDROIT Cape Town Convention, its protocols on interests in mining, construction, and agricultural equipment, and model texts on factoring. These are obviously important instruments for the harmonization of private law, providing advantages to enterprises of all sizes. They help construct a more level playing field, realizing practical benefits such as enabling the use of new forms of credit, granting access to crucial equipment, providing certainty for the positions of creditors, and providing registries to facilitate the supervision on high-value equipment. These practical benefits underpin important values: accessibility, certainty, fairness, and empowerment. International tools such as these open new doors to globalize commerce, giving businesses new ways to grow in scale, reach new markets, and minimize risks. It is the pursuit of these values that continues to motivate the development of private international law in general and the work of our panelists today on international private law in particular. We have 4 distinguished speakers who will each share with us their views and rich experience in this field, and I'm very pleased indeed to be joined on this panel by good friends, and it's really a pleasure to see you all again in person. Of course, Deputy Secretary General Anna Veneziano. She will be talking about Cape Town and 2 of the protocols, aircraft and the railways. William Brady Watson, I think on the MAC protocol indeed, and then the second part of the panel will focusing on factoring with Professor Megumi Hara, focusing on UNIDROIT's factoring model law project, and then joining us online will be Mr. Saibul Jin on factoring, also from Beijing, if my understanding is correct. But without further ado, I would like to give the floor to our dear colleague Anna Veneziano to set the stage with Cape Town and two of its important protocols. Thank you very much.
Excellencies, distinguished delegates, ladies and gentlemen, I am particularly pleased and honored to represent here UNIDROIT as its Deputy Secretary General, and I wish to start by thanking, first of all, our distinguished moderator and very good friend, the Secretary General of the ACCH, for introducing the topic of today. And I would like to join in thanking the Chief Executive and the Commissioner for the introductory welcome, as well as the government of the Special Administrative Region of Hong Kong and the Department of Justice for the kind invitation. As our moderator has already said, I will focus in particular on one of the most successful instruments that was developed by UNIDROIT under the pillar. The Secretary General Tirado has already underlined the importance of access to finance as one of the pillars of UNIDROIT's work. And I hope you will indulge me and allow me to start with Okay, thank you very much. To start with this map. This is the map of the ratifications of the Cape Town Convention. As you see, the blue is the ratifying states. We are particularly proud of the global success of the convention, particularly through its aircraft protocol. As Secretary General Tirado already said, this is by now the international legal framework for the financing in the aircraft industry. We have 83 contracting states in all continents and counting, and 25 contracting states in the broad Asia-Pacific region. And we would like to focus on this instrument and its protocols, not only the aircraft protocol, which already entered into force, but also two protocols that will enter into force soon, hopefully, the Rail Protocol and the MAC Protocol. Now, but I would like, however, to start with why the Cape Town Convention was developed. And first of all, the starting point was the growing global need for finance, and particularly private finance, in the acquisition and use of high-value mobile equipment, which was initially particularly evident in the aircraft industry, and then we realized that it was equally applicable for other industries where you had high-value mobile equipment. But there were, and there are still, legal obstacles in using asset-based finance and leasing, particularly in cross-border transactions, without a uniform legal framework, partly because of the traditional conflict of law approach, but also because legal systems vary in their approach to the recognition of security interests, how to enforce them, and the remedies available, and not all legal systems are equally effective. And so the solution is the uniform legal regime created by the convention and its protocols, which increases certainty and reduces risks in the financing and leasing of certain types of mobile high-value equipment. In the aviation industry, as already said, airframes, aircraft engines, and helicopters. In the rail industry, which encompasses a broad range of railway rolling stock, from high-speed trains to commuters, trams, undergrounds, the space industry, the satellites and other space assets, and then the mining, agricultural, and construction sectors for high-value equipment used in these sectors. And here we see the architecture of the convention. The Cape Town Convention, as a general treaty, provides the common core of rules, and the protocols adapted to the needs of the particular equipment or the particular market, and that's why we have this binary architecture. Now, how does the Cape Town Convention and its protocols achieve this goal? It offers parties to a security agreement, to a retention of title sale or leasing, on the assets covered by the protocols, the option to create and to register internationally an autonomous international interest, which does not displace existing domestic law, but it's more effective and it's enforceable in contracting states. And this results in the removal of the legal obstacles to cross-border use and enforcement of asset-based financing devices. It generally improves predictability. It was said already that predictability and certainty is the basis for these financing transactions, and it lowers the cost of credit. So we have more certainty, less risks, and lower costs. And this sounds a little bit like a slogan, but actually we do have the example of the aircraft protocol to see that this is really quantifiable in practice, that this really happened. So, of course, there we have the political acceptance of the treaty we have already seen before, but I would like to focus on the economic benefits of the treaty, and in particular, the volume of transactions since 2006, entry into force of the Cape Town Convention and its protocols, more than 1.3 million registrations in the dedicated aircraft registry, and an estimated value of collateral of 650 billion US dollars and counting. And again, the quantifiable economic benefits deriving from the lowering of the cost of credit. We have some examples here. The Cape Town discount, which is practiced by export credit agencies under the umbrella of the OECD for debtors with their seat in Cape Town countries, improved rating in recourse to capital market debt financing, and better conditions, generally speaking, for commercial credit, including leasing operation. All these quantifiable, and that's why we have the economic benefits which are tangible. Now, allow me now to very quickly look through some of the key legal aspects of the convention and its protocols, and I focused on three of them. The first one is the international interest that I already mentioned. The core element and feature of the Cape Town Convention system and its protocols is the international registry, a dedicated international asset-based and wholly electronic registry for each of the protocols, which ensures transparency and predictability, effectiveness as against competing creditors and in insolvency, and it offers clear rules for determining priorities, so the certainty and predictability we were talking about. The other feature is effective enforcement measures applicable also in insolvency for creditors' rights, which puts the creditor in a position to feel more secure and therefore to be able to offer cheaper credit, or in some situations even to enter into a financing relationship. The CTC provides effective and swift enforcement measures, out-of-court remedies if states so allow, and this includes also advance relief pending final determination during court proceedings. Now, There is also the last point I would like to mention, flexibility achieved through declarations. To a certain extent, states can make policy choices, and they have done so. And I think the most interesting element here is that states can and have introduced additional elements in the protocols, in particular the aircraft protocol, to strengthen creditors' rights in enforcement and insolvency, which has developed and the economic benefits in practice of the protocols themselves. So, of course, the single protocols then have additional enforcement measures depending on the market and the asset. For example, the aircraft protocol had a special deregistration remedy in order for the creditors to exercise its rights. Now, allow me to conclude this presentation by referring to the second protocol to the Cape Town Convention, the Rail Protocol. The reason why we would like to underline this protocol, which is not yet in force, is because it's on the brink of entering into force with the imminent ratification of Spain and South Africa, and therefore, since we hope it will become a reality in international markets soon, then we would like to present it to this audience. And the Luxembourg Rail Protocol extends the benefits of the Cape Town Convention to the rail sector, adapting the general framework to the specificities of railway rolling stock financing. I have already underlined that it has a wide application, both for passenger and for freight transportation, and it's particularly important in the rail sector because a few legal systems have a functioning domestic legal framework securing creditors using railway rolling stock as collateral, and also because of the difficulties in cross-border acquisition and use of railway rolling stock equipment backed by asset-based financing. There's also a lack of global system of identification of rolling stock, which the registry will provide. So there are economic advantages for the use of the railway protocol because as the Cape Town system in general is expected to attract more private sector lenders and lessors in the rail market, resulting in cheaper finance. The protocol will also allow states to concentrate public resources on rail infrastructure instead of the acquisition of railway rolling stock. And the protocol will also support, as the Secretary General already said, current international commercial networks, particularly the Belt and Road Initiative. And this is just an example of a complex group of transactions that would be highly facilitated by the existence of a general international legal framework, lowering the cost of this transaction. It is based on a real case scenario. Now, my last slide on the rail protocol regards the additional benefits that this protocol would introduce, the social and environmental advantages going in the direction of sustainability we have already mentioned. The protocol will foster economic and social development by enhancing sustainable mass transportation of people by rail, and this is crucial in many areas of the world, but it also will facilitate the use of railway transportation, including cross-border, supporting many of the global sustainable agenda of the United Nations. And this was recognized by intergovernmental bodies such as the United Nations Economic Commission for Africa, the UN Economic Commission for Europe, the African Union, the European Union, and we hope that this can also be considered important in the Asia-Pacific region. I will be very happy to answer any questions or comments on this, and I would like to conclude by thanking you for your kind attention and showing the entrance of a beautiful building in Rome, hoping that you will be able to see us and visit us soon. Thank you very much for your attention.
Very much indeed, Deputy Secretary General Veneziano, for setting the stage so effectively of what we're going to discuss, and hopefully also take a few questions later on. From my part, I can only again congratulate UNIDROIT, both its secretariat and indeed all its members, for the very important and huge success that the Cape Town Convention and its protocols is and are. So I'm extremely, extremely happy for all these achievements. But without further ado, let's go into some more details into the MAC protocol in particular, and it gives me pleasure to introduce to you Senior Legal Officer William Brady-Watson. Please, you have the floor.
Thank you. Distinguished delegates, honourable representatives, ladies and gentlemen, it is my pleasure here this morning to speak to you all about the Mining, Agriculture and Construction Protocol to the Cape Town Convention. Now, those of you who are familiar with UNIDROIT, you probably know that we do a lot of work in the area of access to credit. We have no less than 10 instruments in this field. We have that going right back to the 1988 Conventions on International Factoring and International Financial Leasing, the 2008 Model Law on Leasing, the Cape Town Convention and its 4 instruments, and of course the 2 in development, the Model Law on Factoring and the Model Law on Warehouse Receipts, and we have even more in the pipeline for our future work program. So it might seem strange that today, when we have all of these instruments, we're spending 2 of our 4 presentations on the Cape Town Convention and its protocols. But that's because we are so convinced that this treaty system in particular has such significant legal and economic benefits for the Asia-Pacific region that we felt we had to dedicate 2 entire presentations to this topic today. So I would like to spend the next 10 to 15 minutes speaking about why we developed the MAC protocol, its legal benefits and its economic benefits, in particular for this region, and then spend a couple of minutes on going forward as to what the next steps are to get it into force. So the MAC protocol, as you're aware, is, as the Honourable Secretary General referred to as, it is the toddler, because it's only been around for a few years. It is the newest instrument, it is the newest treaty that UNIDROIT has developed, and in fact the only treaty we've developed in the past 10 years since the Space Protocol. So why did we decide to develop? Well, as outlined by the Deputy Secretary General, it was because primarily of the outstanding success of the mother treaty, of the Cape Town Convention and of the Aircraft Protocol. Now, the Cape Town Convention was developed in 2001, entered into force in 2006, but already in 2006, it had become extremely clear it was a huge success. It was already clear at that point that it was going to revolutionise cross-border financing for high-value assets. So in 2006, the UNIDROIT Governing Council said, how can we extend the benefits of this wonderful treaty to new sectors? In particular, they wanted to look at how they could utilise this new international legal framework to assist developing countries and emerging economies, and to address issues of global concern: food security, infrastructure, climate change, sustainable development. So in 2006, they took the initial step to start researching whether it would be possible to extend the Cape Town Convention to the mining, agriculture and construction sectors. Now, as our dear moderator here, the Hague Conference Secretary General knows, treaty negotiation is a long process. You have to get it right. You don't get a second chance at it. So we started it quite a while ago, and we finally finished it in November 2019. So the core rules of the MAC protocol are consistent with the existing Cape Town Convention and other protocols. This is because of the success of those of the treaty system itself. It has 83 contracting states. It has revolutionised aircraft finance. So the core legal rules, the core structure of this treaty is the same as its predecessors. It covers security agreements, retention of title agreements and leasing agreements. It establishes an independent international registry in which you register your international interest to create priority. There are clear enforcement rules on default and insolvency. And in fact, the MAC protocol has somewhat strengthened rules in relation to insolvency that are a little bit more simple than its predecessors. So the core elements of the treaty are the same. However, of course, there was the need to make some changes because, as any of the finance lawyers in this room know, the financing of an aircraft is very different to the financing of a harvester or mining equipment or a large crane. They're different financial arrangements, so we had to change some of the rules in the treaty to address these peculiarities or the unique aspects of financing in the mining, agriculture and construction sectors. The biggest hurdle was the fact that mining, agriculture and construction equipment is not as high value as aircraft, rail and space equipment. When you're talking about planes, you're talking about assets worth tens or hundreds of millions of dollars. However, of course, in the MAC sectors, of course, you do have harvesters, drills, cranes worth $10 million, but you also have lawnmowers and very, very small tractors that can be worth very, very little or could be used in a domestic, personal, household setting. So we couldn't simply say the MAC protocol applies to agriculture and construction equipment because it would have captured a whole bunch of low-value equipment that was not appropriate for an international treaty covering commercial financing for commercial use. So instead, the MAC protocol uses the harmonised commodity and coding system to identify trade codes, 56 codes that cover this type of equipment and categorise it for international trade. Any of the trade lawyers in this room who've developed bilateral trade agreements or multilateral trade agreements will be extremely familiar with the harmonised system. It's developed by the World Customs Organization. It's the basis of all international trade around the world. It breaks up all commodities traded across borders into 5,000 codes. And those 5,000 codes are the basis of all international trade agreements. So of those 5,000 codes, we identified 56 codes that cover high-value mining, agriculture and construction equipment. Now 56 out of 5,000 may not sound like many, but these 56 codes cover $123 billion of MAC equipment traded across borders every year. So we're talking about very, very large sums of equipment being traded. Now, one of the benefits of also using the codes is it allows states, when they ratify the treaty, to choose whether they wanted the treaty to apply to all three sectors, mining, agriculture and construction, or limit it to just one or two sectors. A country could say, well, we need this instrument will assist in access to finance for the agricultural sector, but we don't want it to apply to the construction sector, and they can make a declaration limiting it to one of the few annexes. So here you see at the bottom of this slide, on the far left you have the mining equipment, the drill, in the middle the agricultural equipment, and on the right the construction equipment. So this is the MAC, and you have the mining equipment in Annex 1, agricultural in Annex 2, and construction in Annex 3 of the treaty. The MAC protocol also has some other individual rules that are different to the previous conventions. We had to, in addition to its harmonised system scope rule, we had to develop new rules for the relationship between mining, agricultural and construction equipment and immovable property, because of course, as you can see from this crane, you can have a crane that is connected to land when it's being used, and under different legal systems, the relationship between a secured interest in that crane and the owner of the property will vary, and there is very little harmonisation on this area. However, it is very hard to harmonise immovable property law because it's considered an issue of sovereignty for many states. So we had to tread very lightly around this issue. The MAC protocol allows a contracting state to make a declaration that determines the interaction between immovable property interests and international interests in MAC equipment. They can choose from 3 different options, and this is how we got around this issue to make sure that we gave contracting states sufficient flexibility to make sure that they could both respect and ratify the MAC protocol, but still retain some control over their sovereign interests and the regulation of immovable property. The MAC protocol also has a special unique rule on inventory financing that allows contracting states to essentially declare that the MAC protocol doesn't apply to equipment held as inventory, to preserve existing inventory arrangements in those states if they already work very well and they don't want them to be disrupted. So that is the sort of the legal summary of the main benefits and differences as compared to the previous protocols. But now the next few slides is why we really wanted to present this treaty here today. It's the economic benefits. So before we concluded the MAC protocol, we asked a team of British independent economists to conduct an ex-ante economic assessment on the potential benefits of the MAC protocol globally, and the results were quite staggering, even surprised us to some extent. So over a 10-year period, the MAC protocol was predicted to increase the stock of MAC equipment around the world by $90 billion and increase global GDP by $30 billion. And very interestingly, as you'll see here, the split of that $30 billion a year in increased global GDP is $23 billion for developing states and $7 billion for developed states. And that's for the very obvious reason that developing states tend to rely more on their primary industries, on the mining industry, on the agricultural industry, whereas developed countries tend to ship more of equipment. And the benefits for this treaty are much more for the sectors that utilise agriculture and mining much more than the manufacturers, even though both benefit. So this is very much a treaty that mainly benefits developing countries and emerging markets. So one of the benefits of using the harmonised system codes to determine the scope of the protocol is it also gives us access to trade data, so we know exactly how much, based on the UN Comtrade system, which regulates international trade data around the world, we know exactly how much each year countries are trading mining, agriculture and construction equipment within the scope of the MAC protocol. So of the 56 codes within the MAC protocol, that covers $34 billion of exports in the Asia-Pacific region. The largest amount is construction for $31 billion, but all of them are over $20 billion. So it's very significant for all three sectors across Asia-Pacific. And we've also listed here the largest exporters and the largest importers. So you have 7 importers of MAC equipment under the scope of the treaty, all over $1 billion. So the MAC protocol will decrease the cost of finance for over $1 billion of imported equipment for these 7 countries should they sign up to the treaty. And we also have the largest exporters there. Japan, China and India are major manufacturers, whereas Singapore is a major trade hub. So we suspect that most of the equipment being exported from Singapore isn't necessarily being manufactured in Singapore, it's just being transited through there as it's as sort of a trade good. So this map shows net flows of import and export. Now it's important to note that there is no, good or bad colours on this map. It's not good is green, bad is red. Green means you're a net exporter of MAC equipment. Red means you're a net importer of MAC equipment. So the green states will benefit as manufacturers. They will have increased access to markets, they will be able to export more equipment around the world, and they'll benefit on that end of it. Whereas the red, orange and yellow states will benefit if they ratify the MAC protocol because they will have cheaper access to finance to import this equipment. So we suspect that, judging by the economic benefit assessment, the red, orange and yellow countries will probably benefit more, although the one problem with these types of maps is that there are some countries that are big importers and big exporters, China being one of them, and it doesn't quite capture. If you export a lot and import a lot, this map doesn't quite capture both sides of the benefits for those countries. So in particular, China is very, very well placed to become a major beneficiary of this treaty. As noted in my earlier slides, it is the second biggest regional exporter of MAC equipment, but it is also the second biggest importer of MAC equipment. There are only about 3 countries in the world, Brazil, China and India, that are well placed to benefit as both importers and exporters. They get benefits on both sides of the treaty, whereas most other countries only benefit from one side. It will also support the One Belt, One Road initiative because it will allow a construction company, if a debtor is located in China, to be able to undertake construction projects all along the One Belt, One Road in multiple jurisdictions along the global trade network. And an international interest in that construction equipment, even if it moves borders every few months, will be enforceable across all of them if the company is based in China and if China has ratified the MAC protocol. So it's very beneficial for that particular initiative. Also, we note here that China is a contracting state to Cape Town of aircraft, and we're very grateful to have been very closely involved in the negotiation of the treaty. So this is my final slide. I hope by this point you're convinced of the value of the MAC protocol in the Asia-Pacific region. So we thought I'd spend my last minute explaining where we are and what happens next. So for the MAC protocol to enter into force, we need 5 contracting states. We need an international registry that's operational so companies can register their MAC equipment to protect their interests, and we need a supervisory authority. So on the right side, you have the more administrative technical requirements. On the left side, you have the states that we need to get. All the administrative parts are moving very smoothly through the MAC Preparatory Commission, which is a group of 16 sovereign states, including China. We believe that we will have the registry established in 2024. We will have a supervisory authority appointed next year. So we're looking at the next 18 to 24 months. The infrastructure for the treaty will be set up and ready to go. What we need is the 5 contracting states. So we have 5 signatory states, and also the European Union has also signed the MAC protocol. So you see here that it's a mix from all across the world. You have Congo, Gambia, Paraguay, Nigeria, the US, and the EU. But we need more. And as I think I've hopefully demonstrated here today, this treaty has great economic potential, in particular for this region. And we hope that we can work with countries across Asia Pacific in the next 2 years to assist them in implementing the MAC protocol so they can realise its full legal and economic benefits once the registry is ready for operation in the next 2 years. Thank you very much.
Thank you very much indeed, William, and you did a brilliant job in showing the economic importance of that protocol. I don't want to put you on the spot, but can you just comment a bit more on who made the economic assessment and how they went about this, just to understand the context a bit broader? That might be helpful, please.
Sure. Yeah, that's working. Thank you very much. So the independent economic assessment was undertaken by 3 economists who were former high-level economists from the UK government that we contracted independently. They used essentially the data from the existing protocols, so from the aircraft protocol. They looked at how much the decrease in the cost of credit was a result of that treaty. They looked at the global trade data in relation to the 56 harmonised system codes. And then they looked at, the group of states they looked at, which I didn't actually mention, was actually only limited to UNIDROIT member states. So they actually limited the economic assessment to the 63 UNIDROIT member states, which is actually, as we know from the Cape Town Convention, which has 83 member states, actually probably less, it was probably on the more conservative side. So they were the parameters they used, and then they used a 10-year time frame. And so this is what we believe, if you average it over for these 63 countries over a 10-year time frame, looking at these 56 harmonised system codes and this 1% cost of credit and essentially longer secured interest times. And that's how they came up with those numbers. We're very happy to share in the materials for this workshop the very long and robust analysis itself, which is also available on the UNIDROIT website.
Thank you very much, William, for these additional comments. And without further ado, then I'm sorry I had you stand here, Megumi. Professor Hara, I give you the floor to talk to us about the UNIDROIT factoring model law. Please. Yeah.
good morning to everyone. I'd first like to thank the Special Administration Region of Hong Kong and the Department of Justice for inviting me to such a prestigious event. Today, I would like to talk about the factoring model law. As the Secretary General of the UNIDROIT has mentioned, the MAC protocol is at the toddler stage. This has not been, it's not even a toddler yet. I'm not going to further deepen the analogy here, but so we are working on this project. So it's very crucial that we have from all of you here on the floor. So the UNIDROIT's factoring model law is basically a model law on factoring. So it is a model law for states looking to implement domestic factoring law. So factoring is basically where the factor purchases receivables owed to, for example, an SME, small, medium-sized enterprise, in a manner that the SMEs do not retain any interest in the receivables that could be included in its estate upon filing for insolvency. So factoring provides finance, particularly to SMEs that sell goods or provide services. As I said, the factoring model law is a comprehensive private law regime factoring transactions. So the project first commenced in 2018 when the World Bank has proposed to UNIDROIT to commence creating this factoring model law. The Governing Council of UNIDROIT has accepted to work on this in May 2019, and since then, for about 2 years, the working group has been working hard on creating this model law. We have another working group in 2 weeks, I believe, and then we will plan, we are planning to finalize the product, and this product should be adopted by the Governing Council next year. So the publication of the model law should be by the end of 2023, and we also plan to create a guide to enactment after that. So as I mentioned, the working group is working on the draft of this factoring model law. The working group consists of 10 independent international legal experts in diverse jurisdictions. So from Asia, I am one of the working group members. There are another from Australia, so we have representations from Asian countries. And there are civil law countries, there are common law countries, so we are very, very diverse. But this working group is not only one element of the drafting process. We also have representations from international organizations such as UNSTRAL or World Bank. They help us, they have an input on consistency with existing international instruments. I will explain about this later. We also have inputs on the implementation situation in countries that are implementing modernized secure transaction law or factoring law. So the World Bank is a major player in helping countries implement these modernized secure transaction law or factoring law. So they help us with what kind of situations these countries are facing. But another really important aspect or important element in this process is that industry is involved in every step of the way of this procedure. So every meeting there will be industry representatives from many organizations that help us guide through the necessity of these industries. So they tell us what the industry's needs are, and they also help us with inputs on modernization of factoring, because this is a field where technological development, such as the technology of blockchains, have really facilitated in creating new products for factoring. So as I mentioned, there are already existing instruments internationally and regionally that deals with transfers of receivable. So three major instruments are the UNIDROIT's Convention on International Factoring. Another is the UNSTRO's Assignment of Receivables in International Trade. The third one is also UNSTRO's Model Law on Secure Transactions. So why are we creating a new model law when we already have existing international instruments that cover transfer of receivables? There are reasons. The first factoring convention by UNIDROIT is limited in its scope that it deals with international factoring, and it is a convention. So it is not catered for domestic factoring law. The second one, UNSTRO's Assignment of Receivables, is also a convention. So it is international, it covers international assignment. It also covers assignment of international receivables, but it is also not catered for a domestic factoring law. The third one, UNSTRO's Model Law on Secure Transaction, it is a wide general secure transaction law. So if a state wants to create a law on factoring, they will need to pick up certain provisions from this secure transaction model law, which could be very difficult for a state who is at first facing this modern secure transaction. So these instruments, although they have helped us create international consensus on what the law should be, are not really targeted to domestic factoring law. And there are also private organizations and international regional financial institutions who have created model law, but they are not really an international consensus building model law. So we do need something that have this kind of international organization backed up with an inclusive drafting procedure. So I am a bit repeating myself, but why do we need the factoring model law? As you can see on this slide, the evolution of global factoring volume is just going up consistently. So there is a growing demand for factoring law. So states see all these industries wanting to have this factoring regime. But then, as I mentioned, because there is no domestic factoring regime that the states can look as a model, there have been a proliferation of standards by individual consultants that help these states implement the law. So we are seeing a diverse factoring law, and we need some harmonization here. Another point that is important to make is that even though the state have modernized its secure transaction law, they could divert from the secure transaction law when they create a factoring specific law. So we need to show what would be the factoring model law that is in line with the international standard. So we are targeting two types of jurisdictions. One is seeking to modernize its factoring regime before considering a comprehensive secure transaction law reform. So a state may not yet have a modernized secure transaction law, but then they see this growing demand in factoring and wish to create a factoring-catered model law. Another type of a jurisdiction that we are looking into is after they have modernized their secure transaction law, identifies a need to create a factoring-specific law. So we are targeting both of these jurisdictions. So here I am stating the necessary frameworks and existing problems when you facilitate a factoring transaction. So there needs to be an adequate legal framework. There needs to be a registry system. There needs to be, of course, people who are experienced in this transaction. And then there is also an important factor that there is a regulatory restriction or regulatory rules. But then there exist problems in all of these pillars that the law could be outdated, the registry system may not exist or could be dysfunctional, or there are no people who are actually fluent in this transaction, And there could be a situation where these regulatory restrictions in a state are not enough. And let me take an example of Japan, where I am from. In Japan, we do not actually have regulatory restrictions on factoring. This causes two issues in that, one, that a state who is, or a factor who is very cautious to a factoring business will not want to create an issue of them being a lender, because lender is restricted by regulatory rules. So they limit their factoring business to a very small type of transaction that they are sure that will not be considered as a lender. On the other hand, there could be a situation where, because these factors think that, oh, I'm not a lender, I can do anything. So they would charge their clients with astronomical fees and create an issue where they are basically violating the usury law. So they have basically a very high interest rate. So these issues need to be dealt with, and the model law will deal with the legal framework, whereas we expect that the guide to enactment is expected to address the regulatory issue. So this is the content of the factoring model law. We have the scope provisions. The Chapter 2 on transfer of receivables are rules between the parties that create basically this kind of transfer. We have a very simple rule that the agreement needs to be in writing and certain elements. Chapter 3 deals with how the factoring or the transfer of receivables are effective against the third party, the sole method being registration. Chapter 4 is on registration system, and Chapter 5 on priority of transfer. So these rules are based on the fact that the sole method of priority or third-party effectiveness are to be done by registration. And there are rules on contractual right between the parties, and Chapter 7 deals with collection and enforcement, this being the extrajudicial method, and that the parties, the factors can actually collect their receivables, but they can also sell the receivables as well. Chapter 9 mentions transactions. That is my mistake. This should be transition rules. And there is also an annex who require a registry. So the key features of the factoring model law. We have a very broad understanding of factoring. This is very important because we cover outright transfer, but we also cover security interest on receivables as well as security transfer. We found from the industry that recently they do a business outside of the outright transfer, which is that they could create a security interest over these receivables. So we need to include this as part of our model law. We apply this factoring model law to trade receivables, which means that this is a type of receivable that is contractual right to a payment of sum of money. And it is limited to goods or services, as well as IP rights, rights arising from IP rights, as well as, what am I missing? The third is, okay, I need to check. Okay, here we go. Credit card transaction. So these are the type of transactions that we are looking into because these are what the factors need. Another important factor is the effect of anti-assignment clause. This we follow the international standards, and we have a complete override of contractual limitations on the transfer of receivables. This goes even farther than the Anstral's model law on secure transaction in the sense that we do not even allow the debtor to claim for compensation even if the transferor violates this anti-assignment clause and actually transfers. So we are in line with the international standards, but we do go farther in a sense that we are creating a rule that do not even allow for a compensation. Another point that I have stressed already is that third-party effectiveness and priority are solely based on registration. So we do have a separate annex for a state who wishes to create a robust registry system. And then we also have a rule on choice of law, because we know that there are a lot of volumes of international factoring, so we require a private international law. And the rule is a location of the transferor, which is in line with the international standards that have already been created by the model law on secure transaction. So I would like to end my presentation in saying that, as I mentioned, there are a lot of technological development in this field of factoring. But then to have a technological development, we need to have a basic principle of factoring put in place, because these products rely on having these basic rules, a basic and robust law on factoring that would aid in creating and further facilitating the factoring transaction and into creating further new products that rely on these new technologies. So I'd like to end my presentation here, and thank you very much.
Let me thank you wholeheartedly, Professor Hara, for your presentation, and all our panelists are doing a great job, because I'm getting questions here from the audience that are just flying in, and one relates to what you just said, Professor Hara, and there's a question: what are the main challenges that you have faced or that you are facing in developing this model law? What are the biggest challenges or problems?
Okay, thank you very much, Dr. Berlusconi, for this question. First, this factoring model law is a product that is in line with other international existing standards. So we needed to really think through what is the core element of these international standards. So we needed to pick up what rules do we really need and to simplify the rules. Because when you look at the model law on secure transaction, it is quite complex in that maybe a state who is looking to modernize its law would not really they could have difficulties in understanding what do they actually need to change, what are the elements. So I think at first it was very important to create a consensus with the group that is drafting this law to really focus on what the concise rules of this existing standard was. But then we also look to the practice, and we see that there are states or practices that actually divert from the international standards. So we really needed to figure out, how do we accommodate these kind of practice into creating this harmonized rule that follows this international standard? So we are very helped with the next speaker. For example, Saibal knows the practice. He is very active in the working group. So he will tell us what the actual practice is, and we will try to accommodate that into this standard. So I think for me, at least, I found that to be a very challenging aspect, and also intellectually a very stimulating and enjoyable discussion with the working group.
Thank you very much, Professor. Great answer, and you're making my job very easy, because now I can just hand the floor to Saibo Jain, who will continue to present on factoring. You are joining us from Beijing, if I'm not mistaken. Let's just make sure that the technology works. I give you the floor, please. Saibo, can you hear us? If you're talking, then we cannot hear you for the moment.
Could you hear me?
Now we can. Perfect. The floor is yours. Thank you.
Yeah, I is just a little bit confused how to control my PPT, but I will try my best. First of all, thank you for the invitation from the organizer of this meeting, and I'm very glad to have this chance to share with the new development of the law in China, especially on the factoring, security transaction, and supply chain. Actually, in China, in the past couple of years, we have faced a very, I could say, the revolutionary change in our law, especially on the security transaction, because the effect of the new civil code, as the new civil code have putting 9 laws together in the one code. But unfortunately, because the time limitation, our lawmaker in the People's Congress doesn't have enough time. Please move to the next slide. I could not control the PPT.
Maybe, Saber, I can just ask you to ask for the next slide to be presented, and then
Yeah.
the technical team here
Yeah.
will take care of it.
Yeah.
We currently
Yeah.
see your structure of the presentation.
Yeah. I just control the PPT.
Can I ask the technical team, can you confirm that you can change the slides for him? Could I just get a thumbs up or response? You can change the slides for Saber. So Saber, you don't have to worry about changing slides. Just ask
Yeah.
when you want to move to the next slide.
Please change to the.
And the team will change the slides for you.
22 slides, page 3.
So now we see the structure of your presentation, the main content. Do you want to speak
Yeah.
to that?
Yeah.
Okay, and then just ask for the next slide when you're ready. Thank you.
Yeah, page 3 is the structure of my content. And yes, that is the main point in these slides. The first of all is the People's Congress made this civil code, but it is a little bit complicated for the outside people who may don't understanding about the whole structure of the law of secure transaction in this civil code, because the structure in this civil code is being put in the different part of the civil code. same law and the rules been put in the part of we call the part one, the general provision. Some piece of the law have been put in the part two, the real rights, the property law, and some part of the security law have been put in the part three, contract law. So in our civil code, we doesn't have, so we call entire chapter on the security law, security interest law. And we should find the whole secured transaction law piece by piece, and putting them together, then you can get the whole picture of the law on security transactions. Please jump to the page 11. From these slides, you can find the security interest law in China have been divided in the different pieces. And you can also find the security interest law mainly in the chapter in the part two, real rights. And some of them are in the part three, contract law, like the ownership, like the receivable, the factoring law is in the part three, contract law. And the pledge against the movable and the pledge of the rights have been putting in the part two, the property law. That is the very different and a very unique feature in our new law, new civil code. And please jump to the 15, slides 15. From this slides 15, you can find in China, actually, we have a very extensive security interest. You can say it according this Article 440. You can sit in your pledge, your security interest against the bill of exchange, promissory notes, checks, bonds, deposit receipts, warehouse receipt, and the bill of lading, and the transferable funds unit and the stock rights. And you can also sit in security interest against the interruptory property, and you can sit in the receivable existing and to be existing. And you can find if you jump to the page 16, you can find the priority rules and the third-party effectiveness rules in Article 768. In these rules, that if the competitive claim or competitive rights have been, the situation happened, and what is the rules to decide the priority and the the third party effectiveness. That is the civil code, the basic structure. The secondary most important change is the Supreme People's Court have published several judicial interpretation of civil code, because they please jump to the 17th. Because of the effectiveness of the civil code, the Supreme People's Court, they published several pieces of judicial interpretation of the civil code, because the Supreme People's Court have the authority from the People's Congress in 1987. Then they can make interpretation of the civil code. So we can find in page 18 that the Supreme People's Court have published several pieces of judicial interpretation of the how to apply the civil code and the security and the secured system of the civil code, the interpretation of secured system, security law under the civil code. And another important piece of the judicial interpretation is the interpretation to the general provision of the civil code. Last week, as I mentioned in slides 19, the Supreme People's Court have published the judicial interpretation on the contract law for the public consultant. And in this justice interpretation, the Supreme People's Court giving them more interpretation on the rules and laws in the civil code, which is made by the People's Congress. And then we can jump to the page 22. Slide 22, it is the part 3 that the People's Congress, following the civil code, the law of civil code, to completely change the legislation system of the formulated and promulgated by the People's Bank of China is the legislation system. And this new regulation have been published by People's Bank of China in February 2, 2000. That's called the measures for the unified legislation of security over movable and rights promulgated by the People's Bank of China. And that is the national-wide uniform legislation system in the People's Bank of China. And from the general provision, chapter 1, and you can find that these measures try to establish national-wide uniform legislation systems, especially for the security interests. So from the slide, page 28, please move to the slides 28. We can find a lot of security interest can be legislated in these legislation systems. The first of all is we call the inventory materials, like mortgage of production equipment, raw materials, semi-finished products, and finished products. The number 2 is the pledge of account receivable. 3 is the pledge of deposit receipts, warehouse receipt, and bill of lading. And number 4 is financial leasing is also included in this article. And please move to next slide, 29. The factoring, of course, is including in this legislation system. Retention of the ownership is one of the items. And the most important is the article, the sub-article 7 is the other legislatable security over movable and the rights. So that means all the security interest, even does not mentioned in this article, can also be legislated on this system. If the security interest can be legislated in this system, that means that security interest would be finally recognized by the Chinese court. But here is the big exceptional situation is except for the mortgage of the motor vehicles, ships, and aircrafts, pledge of bonds, funds, units, equipment, equity, and property rights in intellectual property should be legislated in another system. Not in this People's Bank of China system. So in China, we have several sets of legislation system, and the People's Bank of China's legislation system is the biggest one. But for the special items like vehicles, ships, aircrafts, and bonds, funds, unit should be legislated in another legislation systems in China. Please move to slide 31. It is part 4. As I have mentioned in the part 1, in the civil code, we have a very detailed rules and laws on the priority rules and third-party effectiveness, and what is the means delivery, what means position, what means the legislation. And we also have a lot of rules, like slide 33. It is the article 763 is about the how to deal with the situation of the competing claims on the same receivable. And the slide 34 is the very important article 768. And a lot of rules is about what means the bona fide counterparty in slide 36. In slide 36, what means bona fide counterparty, what is the proper buyer and the due process, and what is payment means payment of a reasonable price, and what mean the buyer should know the exact security interest already on the property. And the last piece of my presentation is the part 5, because I don't think the Law Society outside of China, they don't understanding the very important part of the legal practice of the Chinese court, because the Supreme People's Court and the different level court in China, if as shown in slide 38, the part 5, that means in China, we have hundreds of Chinese court, and every year they have made thousands of cases against on the case on security interest. So we can find in the slide 39, we have hundreds of cases on letter of credit, demand guarantee, and the retention of the retain of the ownership, the price mortgage, cases, and the warehouse receipt pledges and the warehouse goods pledges. Every year we have hundreds of cases on this kinds of case, and we have a lot of case against on the bill of pledge, on the bill of lading, and the pledge of on the railway receipts. We have another hundreds every year. We have hundreds, thousands of cases on pledge on bill of lading, and the forfeiting case, and the domestic letter of credit and domestic forfeiting case, and the cash deposit cases. So you can find in China
Mr. Shen, I'm sorry to interrupt you, but I'm getting signals to ask you to please wrap up because I would like to take 1 or 2 minutes for some questions, please. I do apologize for imposing on you. Thank you.
Yeah, I will directly jump to the conclusion is in the slides 42. That means in China, we basically have established the law on the security interest and very massive rules and laws and judicial interpretations and court case and the registration systems in China. And this whole system can be directly connection with the law in civil code and in civil code country, civil law country and a common law country. And the Chinese law in the future, I do believe, will provide a very extensively opportunity and a chance to doing business with China. Thank you.
Thank you very much, Mr. Shen, for walking us through your presentation despite this technical challenge. If I still can take a minute or two, just because I have a couple of questions that I would like to pose to our panelists. One that I think is also quite relevant for the region, and that is to know if there are plans to add another protocol to the case system that would deal with shipping finance. One of you.
Thank you very much for the question. The idea of extending the Cape Town Convention system to the shipping industry was actually there from the start. It seems to be a natural extension, even before the extensions that we did do afterwards, which we know are very important from an economic perspective. For the moment, however, we have not yet developed this because we have yet to find a complete industry consensus and participation of other intergovernmental organizations and international organizations that are active in this field. It is still in our work program, and it is, for the moment, a low priority project together with other possible protocols to the Cape Town Convention, such as on renewable energy assets and containers, which is connected to the maritime industry. So we really hope, perhaps in the next iteration of discussions on the Cape Town Convention, to be able to say that we have started work on this. For the moment, they are in the pipeline. And thank you very much.
Perfect. Thank you very much. And another question that maybe for you as well is, can you comment on the nature of the involvement of the business sector in developing these instruments? We have heard that this is quite important to come up with solutions that work in practice. How does the business participate in these discussions? Are they observers? Are they on national delegations? Do they work directly with the Secretariat? Please.
Thank you. It's an excellent question, and the Cape Town Convention system and negotiation of the treaty and of the 4 protocols have all deeply involved the private sector. In fact, in many ways, they've been the most important participant in negotiations. And one of the somewhat unique aspects of negotiating the Cape Town is that there's actually been sort of a peak industry body for the aircraft protocols, the aviation working group. There's a railway working group. There was a group of space industry companies involved in the space protocol, and there's also a MAC working group, which represent the manufacturers, the financiers, the end users, and the legal community involved in the financing of cross-border transactions for high-value assets. They all came together to make sure that the treaty was addressing the on-the-ground issues they were finding in cross-border finance for these different types of equipment. So they were an absolutely essential part of it. And also what we found is not only in the negotiation, but in the implementation, they have been the leading voice. One of the main reasons the Cape Town Convention and the Aircraft Protocol have been so successful is because the Aviation Working Group has moved around the world assisting implementing states, because they saw, you know, there was a state that needed financing to acquire new aircraft, and they assisted those states. So they're absolutely crucial to not only the negotiation of them, but also the implementation of the Cape Towns. And we are very honest, we think that's one of the main reasons it's been so successful.
Thank you very much, William. I appreciate it. Anna has something to add, please. 1 minute.
Two very short points. The first is that this method of involving the industry and the business involved or other stakeholders involved is actually something that UNIDROIT uses throughout our projects, and I think also this discussion and different panels we will see that. And second, I would like also to say that the fact that we involved the industry from the start did not mean that we were captured by specific industry interests, but there was always a balance within the working groups of the industry, and also with the voice of the government, the voice of the intergovernmental organizations, the voice of the experts. So I wanted to underline this because it's an important element. Thank you.
Absolutely, and quite rightly so. Thank you very much. This is all the time we have. Sadly, I do apologize, I couldn't go through all the questions, but please join me in showing our appreciation to our 4 panelists for their very informative and excellent presentations. Thank you very much all.
Thank you. Thank you. Wonderful section indeed. Thank you so much, Professor Bernasconi, Professor Veneziano, Brady Watson, and also Professor Hara. Okay, please, I would like to invite 4 of you, please proceed to the center stage so we can have a group photo with Mr. Jin together. Yes, let's have a group photo to wrap up this awesome section indeed. Let's take a photo. Yes, I will stand a bit further away from you guys. I think for group photo on the stage, let's take a moment to capture this important moment together. Please look at the official photographer right in front of you. Mr. Jean, all you need to do is just smile and look into your camera. Yeah, yes, we can capture you indeed. Thank you so much. A big round of applause to Professor Bernasconi, Professor Veneziano, Mr. Brady Watson, Professor Hara, and Mr. Jean. Thank you so much. Please be seated. Before we proceed to our second panel section, we would like to have a 10 minutes break. So please take your valuables with you whenever you leave this hall. Also, please enjoy the refreshments that we've prepared for everyone in the designated areas outside the conference room, and return to the conference room in 10 minutes. For online participants, you don't need to log out. Just enjoy this 10-minute break and we'll be back very soon. So ladies and gentlemen, remember, be back in 10 minutes. See you in a bit. Thank you. Good morning, ladies and gentlemen. I know everyone is enjoying the break so far, but we would like to resume our panel section too. So we would like to invite everyone, please kindly make your way back to the hall and please be seated. Gentle reminder, please do remember to switch your mobile phones and electronic devices to silent mode. Thank you. 咁多位嘉賓，我哋今日即將開始我哋第二個專題討論啦，所以有請咁多位嘉賓可以稍移玉步翻嚟我哋啦主會堂嘅位置，參與接住落嚟嘅環節。多謝咁多位。尊敬的各位來賓，我們接下來將會立馬開始我們今天第2場的專題討論，請各位移步回到我們的主禮堂，接下來參與我們下一個環節。謝謝各位。Ladies and gentlemen, our panel discussion 2 will now resume, so please kindly make your way back to the hall and please be seated. Thank you. 咁多位嘉賓，我哋今日接住落嚟第2場嘅專題討論係立即開始㗎啦。咁我哋不如呢個時候就有請咁多位嘉賓盡快就座，咁等我哋可以立即同埋準時開始我哋接住落嚟嘅環節啦。Thank you. Ladies and gentlemen, good morning. Our panel section 2 will now commence, so please kindly make your way back to the hall and please be seated. Thank you. 咁多位來賓，我哋立即會開始我哋今日繼續嘅節目㗎啦，所以有請咁多位嘉賓立即移步翻嚟我哋主禮堂呢個位置啦。多謝咁多位。 Good morning, ladies and gentlemen. Welcome back to the section of today's summit. And here comes to our second panel section of today, titled Providing Legal Clarity on Emerging Technologies, Digital Assets, and Private Law. And we're delighted to have invited Mr. Jason Lee, Senior Legal Officer of UNCITRAL, to be our moderator. A big round of applause to welcome Mr. Jason Lee. And joining Mr. Lee on stage, we also have Mr. Hamseed joining us online, and Mr. Chan. A big round of applause to welcome Mr. Chan. And Professor Kanda. So, ladies and gentlemen, I think without further ado, it's now time for me to pass the time and the floor to our moderator. Mr. Lee, over to you.
Thank you for the introduction. My name is Jae-Sung Lee, and I'm a senior legal officer at the UNCITRAL Secretariat, the United Nations Commission on International Trade Law. And it's a great pleasure to be back in Hong Kong after 3 years of absence, and more so to be with colleagues from our sister organizations, and also to meet the colleagues from the Hong Kong Department of Justice, whom we have been cooperating very closely with, even during the pandemic. We are starting a little bit late, but as some of the captains in the plane says, we'll try to recover the delay and try to finish on time. And we're actually asked to finish at 12:45. So we're also asking our speakers to make sure that their presentations are very precise and concise and to the point. Ms. Anna Zuban-Brett, the Secretary of UNCITRAL, would have loved to have really wanted to be joining you here today, but was not able to do so because of a schedule. And she sends her best regards and wishes the Hong Kong Legal Week a big success. Now, there are many ways that we can describe the globalized world that we are living in, and one is that we are living in a digital economy. This term applies regardless of where you are located, and one can say that almost everyone in this world is participating or taking part or is a member of the digital economy. Upon arrival in Hong Kong, I received a QR code containing all of the necessary information for me to attend the Hong Kong Legal Week and to go to restaurants, and which is just one illustration of how much technology or digital aspects have become part of our economic lives. We are identified by our phones, we pay with our phones, and we no longer need to carry our IDs or credit cards when we go to shops. It's become so part of our lives, but there are indeed a number of legal issues or underlying legal issues that arise as we engage in such transactions online. Now, this allows me to go back in time and mention that some 25 years ago, so it was quite a long time ago, UNCITRAL, which is also an intergovernmental organization established by the UN General Assembly, which was in 1966, with a mandate to harmonize international trade law, had prepared a model law on electronic commerce, which set the basic legal principles of electronic commerce based on non-discrimination, so they should be treated the same, functional equivalence, as long as they're functionally equivalent, they should have the same legal status, and technological neutrality to ensure that technological developments are not prevented by the introductions of laws, all of which are still relevant in the coming today. And let me fast forward a little bit. You know that what's happening at UNCITRAL, which took place last week. The working group on e-commerce, which is working group 4, commenced work on the topic of the use of artificial intelligence, AI, and automation in contracting, and agreed to prepare a legislative text on those topics, which address some of the other issues, for example, on the autonomous systems, attribution, matters relating to the state of mind, pre-contractual disclosure of information, traceability, liability, which have not been handled within the context of UNCITRAL text yet, and they are going to look into these legal issues as they come. The working group also finalized its work on an explanatory note to the UNCITRAL model law on the use and cross-border recognition of identity management and trust services. So what I'm trying to say is that there are a number of legal issues that need to be addressed in order to facilitate and enable international trade, and UNCITRAL is taking a broad look at all of these legal issues in the digital economy. And we are doing so in close coordinations with our sister organizations. I would say that this legislative coordination seeks to achieve what we refer to as progressive harmonizations. So rather than trying to tackle and try to harmonize laws that exist in the different legal systems afterwards, what we are trying to do is to prevent fragmentations of laws governing such issues. Rather than having each jurisdiction coming up with different approaches and different legal rules and regulations which might deter cross-border trade, we're trying to address them upfront and suggest a unified approach that could actually facilitate trade on the online platforms. And all such efforts aims to, of course, to achieve legal certainty and predictability, which allows the parties to engage in the transactions to have trust in the systems and be assured of the governing legal framework. Now, this panel that we'll have will dive into one aspect of the digital economy. I hesitate, actually, to open my digital wallet that I have on my phone because the prices of my 0.1 Bitcoin and 2 Ethereums have fallen dramatically. But more fundamentally, the questions that we are having to discuss is what are these digital assets that we're trading online? It's not only about virtual currency and tokens, but it's also about NFTs and other digital assets that we see. Those that we cannot see, those that don't have a physical shape, those that are not tangible. Where does the value arise, and what are the legal issues that relate to these digital assets? So to address this topic, we have 3 speakers today. 2 of the speakers will be joining online, Hamza from Rome and Hideki from Tokyo, and Undersecretary Joseph John being my only companion in this room. Just to shortly introduce the speakers, Hamza Hamid is a legal consultant at UNIDRAW, working in the area of spacecraft financing, secure transactions, and law and technology. Mr. Joseph Chan is an Undersecretary for Financial Services and the Treasury, who has many years of senior executive experience in the banking industry prior to his appointment as Undersecretary of Financial Services. He will address the question of how the development of virtual assets fits into the global financial regulatory framework, given its evolving nature. Hideki Kanda, who will be joining us shortly, is an emeritus professor at the University of Tokyo and a professor at Gakushin University. He's a member of the Governing Council of the UNIDRAW and chairs the UNIDRAW Working Group on Digital Assets and Private Law. So with that, let me pass the floor to Hamza Hamid, who will touch upon the history, structure, scope, and the definitional aspects of the UNIDRAW project on digital assets and private law. With that, Hamza, you have the floor.
Thank you very much, Jay. Good morning, dear colleagues, friends, and representatives of international organizations, governments, and people involved in the industry. It's my honor and pleasure this morning to talk to you at the Asia Pacific Private International Law Summit taking place in Hong Kong. My great appreciation to the organizers for their kind invitation, and I wish I could have joined you in Hong Kong right now, but I'm delighted to be speaking to you online as part of Hong Kong Legal Week 2022. As Jay kindly mentioned, this presentation is one of 2 discussions on this panel that will touch on the UNIDRAW project on digital assets and private law. My role here right now is to talk a little about the background of the project, as well as what it covers and the types of issues it tries to address, with the chair of the working group, Professor Kanda, later going into some more substantive matters, including our principles related to private international law, secure transactions, as well as the concept of control within these principles. So I'll get started, and then I'll try to stick within the 15 to 20-minute mark, just that I can try to make sure we stay on time, like Jay indicated. So the digital assets and private law project that UNIDWA has been developing quite nicely over the past 2-3 years. My presentation will start with looking at the background and current status of the project, and then digging into some of the various sections of the instrument that we've been producing, and then go towards discussing what some of the future work for this instrument will be. The project started in between 2015 and 2018 when we received two proposals from the governments of Hungary and the Czech Republic to commence work in the area of digital technology, particularly with a focus on smart contracts, digital assets, as well as artificial intelligence. Based on this, in 2019, the UNIDWA Governing Council put a project on our work program to explore issues in this area, and then commenced this exploratory workshop, followed by an exploratory working group, to clearly define the specific focus of UNIDWA's project group in this area. After lots of deliberation, it was determined that the area where UNIDWA could best contribute was in that of digital assets and private law, particularly looking at transactions relating to digital assets and how they operated and worked in the digital economy. The exploratory working group and the working group later identified a great need for governments and different stakeholders from around the world for greater certainty, particularly with regard to the private law issues involving digital assets. And so it was determined that an instrument in this area would be most useful. Since then, the working group has met several times. We had our 6th meeting a couple of months ago, and there have been now 10 drafting committee sessions, all moving towards the finalization of an instrument next year. We have also established a steering committee for the digital assets project, which involves more than 25 governments from different parts of the world that are commenting on the instrument, and to provide their own domestic experience, and to ensure that some of the most important issues in private law and digital assets are addressed. So when thinking about the background and current status of the UNIDWA project, the project sets out to put together principles that embody best practices and international standards. These best practices and international standards relate to private law issues involving digital assets, and issues that can arise from the holding, transfer, and use of digital assets across a variety of commercial use cases. The principles themselves are accompanied with a commentary on practical problems involving digital assets and their use. And the principles adopt a very iterative and functional approach across the board, so as to make sure that they're applicable to a range of technologies and are not very technologically specific. Now, every time I speak about this project, I like to put it into real world examples and actual things that can help listeners understand what we're talking about. And Jay already started this process when he talked about looking at his digital wallet, his crypto wallet in his smartphone, where he'd been storing his cryptocurrencies. And those are the types of things that this project involves, yes. So on this slide, what I've done is I've put 2 ERC721 tokens that belong to me. So these are 2 virtual pets that I hold, and I've put them here to illustrate to you as an example of some of the types of issues that can come up. Both of these creatures that you can see have unique names, characteristics, and identities, and exist as NFT tokens on the ERC721 blockchain. they are on the Ethereum platform. Jay mentioned he has 2 Ethereum. Similarly, these were purchased using Ethereum. I've had them for many years now, but if you look back to the news, you will recall that in 2018, a creature similar to this, not one of these two, sold for $180,000 US between 2 parties online. Now, that's a lot of money. If I was to go to the bank, for example, and if one of my crypto kitties was worth a similar amount, would I be able to use that to borrow money as collateral? If yes, what sort of interest or right could a lender or a creditor create in my digital asset? Would that digital asset be recognized across jurisdictions? Would there be any capacity for a creditor to enforce upon their right in my digital asset? These are all the types of questions that the UNIDWA Digital Assets Project tries to address, not only in relation to NFTs or virtual pets online, but more generally in terms of cryptocurrencies, assets that travel on distributed ledgers of whatever kind, whether that be permissioned blockchains, permissionless blockchains, closed networks, open networks, decentralized networks, including assets that are now becoming increasingly common in the metaverse, which are all on distributed ledgers and on different blockchains. The number of legal issues in these assets has become increasingly more, and the amount of solutions available at the present moment is quite less. And jurisdictions across the world are moving forward at a fast speed to develop some rules on this matter. In fact, I was just speaking to someone the other day and learned that there are now banks in Decentraland, including providers such as JP Morgan, that are offering loans inside a metaverse based all on cryptocurrencies and metaverse currencies, which raises a lot of the problems the UNIDWA project already tries to address. So now I'll dig into some of the principles more on a general holistic level to outline what the scope of the project is and the types of things it tries to address. And as I said, Professor Kanda will then dig into some of the secure transactions law principles as well as the conflicts of law principle. And before I get into it, I'd importantly point out that all the principles that I'm displaying on my slides are accurate as to September 2022, which was the latest meeting of the working group on digital assets. The final version of these principles will be published in 2023. So to start with, as I said, these principles deal with the private law relating to digital assets. They are strictly limited to private law issues and deal only with digital assets, which are then defined in Principle 2, which relates to definitions. Principle 2 relating to definition starts with the definition of an electronic record, which means information which is 1, stored in an electronic medium, and 2, capable of being retrieved. This definition is consistent with international standards and best practices for the definition of an electronic record, and in particular, the UNCITRAL model law on electronic transferable records, which Jay already mentioned. Next, the principle defines what a digital asset means. And according to this, a digital asset means an electronic record which is capable of being subject to control. The notion of control itself is later on defined in the principles, particularly in Principle 6, which refers to control being this non-rivalrous type ability and brings in place certain attributes such as the capacity to transfer control onto another party, such as the capacity to dispose of the digital asset, and we'll get to all of that. The definition of a digital asset, particularly being tied to the notion of control, ring fences the scope of this project to assets that have this capacity to be acquired, disposed, and controlled. So what it excludes is things such as social media accounts, assets that don't have a capacity to be controlled. And what it also does is that it limits the application of these principles to things that might not be acquirable or disposable, such as, for example, Microsoft Excel files and other types of databases. Principle 2 further goes on to define what is principles law, which relates to any part of a state's law which falls within the scope of the principles. Other law, which means state's law to the extent it is not principles law. And then we move to principle 3, which encompasses a set of general principles that are important to identify at the outset. The first one of the general principles in the project is that digital assets can indeed be the subject of proprietary rights. This sets out upfront that an individual can hold a property right in a digital asset, and then the rules pertaining to how these property rights can be enforced, transferred, disposed, etc., follow later on in the principles. Principle 3.2 says that principles law takes precedence over other law to the extent that they conflict. And then principle 3.3 goes on to put in place some areas to which these principles do not apply. This is important to put forward at the outset. And so 3A says that these principles, other law applies to issues including whether a person has a proprietary right in a digital asset. So while the Uniswap principles do clearly suggest that a proprietary right can exist in a digital asset, whether or not a person has it is determined by other law. Whether a proprietary right in a digital asset has been validly transferred to another person, whether a security right in a digital asset has been validly created, the rights as between a transferor and a transferee of a digital asset, the rights between a grantor of a security right in a digital asset and the relevant secured creditor, the legal consequences of third-party effectiveness of a transfer of digital assets, and the requirements for and legal consequences of third-party effectiveness of a security right in a digital asset. Principle 4 continues the list of exceptions, but highlights a very important one. Very often when we speak of digital assets, we also think about assets that they might be linked to, and these principles clearly outline that the other law applies to determine what the existence of requirements for and legal effect of any link between a digital asset and another asset is, whether the other asset be tangible or intangible. As I mentioned, Professor Kanda later on will deal with the private international law rules encompassed within these principles, but I thought I would briefly mention what the definition of control is, which, as I explained earlier, is fundamental to this project, such that it is part of the definition of what a digital asset is. So a person has control of a digital asset if, subject to paragraph 2 and 3, the digital asset or relevant protocol or system confers on that person the exclusive ability to change the control of the digital asset to another person, which is then later on classified as a change of control. The exclusive ability to prevent others from obtaining substantially all the benefit from the digital asset, so the ability to exclude others from that asset. And 3, the ability to obtain substantially all the benefit from that digital asset. And then the principle goes on to describe this requirement such that the digital asset or associated records allow the person to identify themselves as having all of the abilities set out above. It then goes on to talk more about this concept of control, which is that a change of control includes the replacement, modification, destruction, cancellation, or elimination of a digital asset and the resulting and corresponding derivative creation of a new digital asset, which is then subject to control of another person. The reason this principle is structured like this is to recognize the technology that these assets are most regularly transacted on, which is distributed ledger technology on blockchains. So whenever you generally transfer let's say the Ethereum J has to me or my CryptoKitty to J, you would normally see an asset going away and then another asset being created based on public-private key cryptography, and Principle 6.2 captures all of that. And Principle 6.3 talks a little more about this requirement for exclusivity and says that an ability for the purposes of paragraph 1A need not be exclusive if and to the extent that the digital asset or the relevant protocol or systems limit the use of or is programmed to make changes to the digital asset, including change or loss of control of the digital asset, or if the person in control has agreed, consented, or acquiesced in sharing that ability with one or more other persons. This 3B talks about a very common multi-signature arrangements that exist in cryptocurrencies, whereby one wallet might be managed by more than one person, and it recognizes that technology and allows for exceptions to the definition of exclusivity and control to exist. 7 talks about the identification of a person in control of a digital asset. We already talked about this briefly, so I'll move forward. Section 4 of the digital assets principles relates to the transfer of digital assets, particularly the acquisition and disposition of them. The working group is presently undergoing debate as to whether or not to incorporate this section into one of the previous sections, and we'll probably see a different draft of this in the next iteration of the principles. But at the moment, it describes a transfer of a digital asset as the change of a proprietary right from one person to another, and then goes on to capture some of the technologies that I already mentioned. This section also has rules on the innocent acquisition of a digital asset, a shelter rule, and the application of innocent acquisition rule to a custody relationship, which is what the next section talks about. The concept of custody is quite important because many people have various different types of technological limitations, as well as tools in place to hold digital assets. A very common tool that people employ is to have their digital assets held by a custodian. And this principle clearly defines what a custodian is, and then goes on to talk about some of the duties and responsibility that a custodian has, as well as what a custody agreement means. Quite importantly, in the duties owed by a custodian, it very clearly sets out this obligation for a custodian to separate digital assets of its clients into different sections, or at least and to ensure that in the case of the insolvency of a custodian, the digital assets are recognized as the proprietary right of the person that they're being held on behalf of, and are separated from the insolvency estate. As noted, Professor Kanda will talk about secure transactions. The principles end with a section on enforcement, as well as a section on insolvency. Now, given the limited time I have, I will note that the future work of this project includes a industry consultation, which will take place early next year, as well as at least 2 other sessions of the working group, one of which will take place late December, and the final one of which will take place, or perhaps the second last will take place in the early half of next year. We will then hopefully publish the draft the principles on private law and digital assets as part of the UniDoA Governing Council next year. So you can expect to hear more about this in the middle of next year. And with that, I'll finish. If there are any questions, please don't hesitate to contact some of my colleagues that are with you in the room right now, or feel free to reach out to me over email or on social media, and I'd be very happy to talk more about this project. Thank you. Back to you, Jay.
Thank you, Hamza. I'm wondering whether we should be exchanging the 2 kitties with my 2 Ethereum at the end of the day. I'm not sure which one is more valuable at this point. Anyway, I think the slide that you actually indicated, I mean, these are the basic key principles that you need to have in order to consider issues of digital assets. But you also highlighted that what the principles do not address, which are quite a lot. as you can see. And that hints at the fact that these, the issues of legal digital assets, it's linked to a number of different laws. And one other law that we would like to look at today with our next speaker, Joseph Chan, is the regulatory framework for the use of such digital assets, more particularly on the licensing regimes of certain digital coins in Hong Kong. So with that, I'd like to pass the floor over to our next speaker, Joseph Chan, to look at the regulatory framework, which also the principles do not address. Please.
Thank you. Good morning, everyone. It's my pleasure to be here with you to share for 15-20 minutes about this topic on the virtual assets licensing regime in Hong Kong and also the related development of digital assets. Well, to begin with, I would like to share with you that from our observation, the DLT, distributed ledgers technologies and blockchains could be used to facilitate the growth of real economy. And in fact, a lot of financial innovations have come up from these technologies already, and they promote cost efficiency and also inclusiveness. But of course, at the same time, they have to be careful about the potential risks from such development. So that's why on one hand, we recognize virtual assets, but at the same, and also it promotes future opportunities into Web 3.0 and also the metaverse. But after all, it could also induce certain concerns such as investor protection, such as the risk of money laundering, as well as terrorist financing. So that's why I think from a regulator, from a government perspective, we need to balance between development and also risk management. Well, last week we held the we held the FinTech Week 2022 here in Hong Kong, during which we actually published our policy statement on development of virtual assets. On that statement, basically, we want to show a very clear pathway and about our vision and approach to the industry. So while Hong Kong, we are open and inclusive towards the global community of innovators engaging in virtual asset businesses. We aim at providing a facilitating environment for promoting sustainable and responsible development of the virtual asset sector in Hong Kong. But at the same time, we will, of course, provide timely and necessary guardrails to mitigate actual and potential risks in line with international standards. So the government, in conjunction with our financial regulators, are working towards providing a facilitating environment for to promote sustainable and responsible development of the VA sectors in Hong Kong. And we are ready to calibrate our legal and regulatory regime as part of our effort to provide the aforesaid facilitating environment on this juncture. And also, we want to emphasize that we will adopt what we call the same activity, same risk, same principle. We believe that it's important because after all, in the financial industry, there could be different activities, also some new products and services coming from renovation. So regardless of the background or technology, we adopt this same activity, same risk, same regulation principle. The actual and potential risks, be that on financial stability, consumer protection, money laundering, terrorist financing, definitely we believe they have to be, and we will work towards to get these risks to be mitigated and managed in line with international standards. In terms of regulations, in this policy, we set out a few of them. Well, first of all, we will be providing a licensing regime for the virtual asset service provider. We believe that with consistency, predictability, and clarity gradually established in our regulatory framework, then we will have a solid foundation to further enhance financial innovations and technology development brought by the rapid development of virtual assets. And the new regime will align requirements for virtual asset exchanges, particularly in terms of anti-money laundering, counter-terrorist financing, and investor protections to those currently applicable to traditional financial institutions. Hence, we're offering licensed virtual asset exchanges the status and credibility to access a wider net of investors in Hong Kong. The other item is the exchange funds on virtual assets in our market. So Hong Kong is open to the possibility of having exchange-traded funds, ETFs, on virtual assets. So our regulator, SFC, has also published a circular on this subject afterwards. That's we're looking into it. The other item is we will be doing a public consultation on how retail investors may be given a suitable degree of access to virtual assets. Just to share with you the background, the upcoming regulatory regime on virtual asset service providers or virtual asset exchanges will limit the access to professional investors only. So on this statement, we also say that we are open-minded and we'll do a public consultation where the retail investors in the future will be allowed to have access to them. And the other item is stable coins. So in terms of stable coins, what we want to outline is that at the moment, Hong Kong is actively looking into stable coins, and in fact, our central bank or our banking regulator, the HKMA, Hong Kong Monetary Authority, has already issued a discussion paper on this subject, seeking feedback on putting in place a risk-based, proportionate, and agile regime for regulating activities related to payment-related stablecoins. So the consultation outcome and the next steps will be announced in due course. And also the last item I want to share with you under regulation is that we will do a review on property rights for tokenized assets and the legality of smart contracts as well. In addition to regulations, on this policy paper, we also set out 3 particular pilot projects to show our commitment to developing the virtual assets in Hong Kong. Well, the first one is that actually during FinTech Week last week, we issued NTF for the FinTech Week participants. So as a proof of concept project on our part from the government to engage the FinTech and the Web3 community. And the second one is green bond tokenization. As a background, the Hong Kong government has been issuing government green bonds since 2019, and we're looking into tokenizing the government green bond issuance for subscription by institutional investors in the future. Well, that will cover like the issuance, the life cycle, settlement, redemption, so on and so forth of the bonds. And also the third pilot project is e-Hong Kong dollar. So because e-Hong Kong dollar is potentially a backbone and anchor bridging legal tender and virtual assets, offering price stability and confidence needed to empower more innovation. Well, moving on from the policy statement that we announced last week, I'm going to look into or share with you on a few specific virtual asset related subjects as well. Well, since I just touched on e-Hong Kong dollar, so I start with that. In Hong Kong, we adopt a proactive and open-minded approach in regard to the issuance and application of central bank digital currency, CBDC. So we hold a view that it will provide a more convenient, secure, and innovative tool for the public and enterprises to make retail, wholesale, and cross-boundary payments. And in fact, just 2 months ago, HKMA released a position paper, right, titled e-Hong Kong dollar charted the next steps to set out its policy stance on the retail CBDC, that is the e-HK dollar. Going into the that paper, what we'll do is we'll adopt a 3-rail approach. The first rail and the second rail will be done concurrently. The first rail is about to develop the necessary technological framework and the legal foundation for implementation. The second rail is to examine the actual use cases, application, implementation details of e-Hong Kong dollar. And after these 2 rails have been completed, then we'll move on to the third rail, which is to set the timeline for launching e-Hong Kong dollar, taking into account the pace of the local and international markets, and of course also taking into account the result from the first 2 rail of such work on e-HK dollar. talking about central bank digital currency, talking about e-Hong Kong dollar, of course, ECNY is also a very important subject. Hong Kong MA has been working with the Digital Currency Institute of PBOC, People's Bank of China, to expand the scope and scale of technical testing of using ECNY in terms of cross-boundary payments in Hong Kong. Well, the first phase of the technical testing was already done a couple of years ago, and now we are in the second phase of technical testing, which includes the testing of top-up of ECNY wallet through the Hong Kong's infrastructure faster payment system, and we have also invited more banks and merchants to participate in this current phase of testing. We believe that it will facilitate Hong Kong residents to use ECNY in the mainland in the future, and also promote the integration of the Greater Bay Area. And of course, when we're talking about the implementation or application of CBDC, especially also on a cross-boundary basis, we believe that it will also promote mutual access within the Greater Bay Area, be that payment services, retail consumption, so on and so forth, and also will be beneficial to Hong Kong as a global offshore renminbi hub as well. Moving on to the global stage, of course, beyond the cross-boundary usage of CBDC between Hong Kong and the mainland, we could also look into the benefits and potential use of CBDC on a cross-border basis on an international level. In fact, the HKMA is conducting the multiple CBDC bridge project in collaboration with PBOC, also the Bank of Thailand, the Central Bank of UAE, and the Bank for International Settlements Innovation Hub Center here in Hong Kong to explore the capabilities of DLT in facilitating real-time cross-border FX foreign exchange payment versus payment transactions. The trial platform has demonstrated the potential of CBDCs in facilitating the real-time cross-border foreign exchange payment versus payment transactions that actually cuts the processing time of cross-border payments from days to near real time. So from a financial operation standpoint, it's a huge jump in terms of efficiency. And we also see that the Ambridge project offers a range of other potential benefits in different use cases as well. So in summary, we'll find that if we look at the Ambridge trial platform that we have done so far, it will help in terms of the cross-border payments to address the issues of high cost, low speed, and also operational complexities. And also, that will also help ensure the policy, regulatory, compliance, and privacy mechanisms could be more appropriately integrated. Moving on from central bank digital currencies, I also want to talk about the tokens in the private market as well. Well, STO, security token offerings, it has been getting more and more popular. So well, what STOs are, right? STOs typically refer to specific offerings which are structured to have features of traditional securities offerings and involves security tokens which are digital representation of ownership of assets. Well, that assets could be a wide range, could be gold, real estate, or any other means, or economic rights, as I mentioned, like share of profits or revenues. And of course, the STOs is utilizing the blockchain technology. At the moment, STOs, at least in Hong Kong, are normally offered to professional investors only. Well, actually, last couple of months, I have met up with more than 10 different parties involved in STOs in Hong Kong. Some of them are issuers, some of them are the lawyers or accounting firms or so. And throughout this discussion, we find that actually we have a strong pipeline in Hong Kong. In fact, STOs have already been issued in Hong Kong before, and I think from our conversations, there were more than another 10 issuers interested in issuing STOs in Hong Kong. From the government standpoint, in principle, we support the healthy growth of fintech, and including STO as well in Hong Kong. as each would provide a wide spectrum of innovative financial services to the community to support the growth of the real economy. However, of course, as I mentioned early on, we need to address the particular risks in terms of anti-money laundering, terrorist financing, and also we need to ensure investor protection. So that's why we will support the development of STO business, but with certain regulatory and compliance requirement in place as well. So I'll round up my presentation here. One last thing I would like to mention is that in terms of the development of virtual asset is still ongoing, it's evolving. It's not, we don't have a final product yet. So you will find that globally, there could be different type of definition per se. And particularly, I would like to highlight that when it comes to virtual asset activities, sometimes we can refer to exchanges. We're talking about the issuers. We could talk about the custodians. And also, other than just the virtual asset activities directly, there could be other type of related products as well, such as funds, derivatives, and also the intermediaries involved in the selling or distribution process as well. So it's a very big topic, and definitely from the government standpoint, we promote financial innovation, but at the same time, we will update and provide the necessary and timely regulations and regimes to ensure those risks will be addressed. Thank you.
So thank you, Joseph. I think you've highlighted one aspect that is actually underlying these issues of digital assets, that there are a wide range of digital assets. We don't know what they are. They are still developing. They're linked with a number of laws, not only, but also with the different sectors. And therefore, it's not only the financial sectors, but it's also related to the cross-border issues. But I think one thing that I would like to get from you is that the regulation that you're trying to kind of impose is to enable cross-border trade by the use of, using virtual coins and also in the transactions of digital assets as well. And I think that's one of the guiding principles of what we are trying to do as international organizations in the field of international law, is to enable and provide an enabling legal framework which would allow for such transactions to take place. So I think that's something that we need to take away from here. I've been told by my organizers that our next speaker, Hideki, is online. And I think he will touch upon one of the main concepts of the digital assets projects of what control is, the private international law issues that arise from there, how to use digital assets in secure transactions and custodian and in the custody assets, which you also hinted at, Joseph. So with that, I'd like to pass the floor over to Hideki. Hopefully he's online and ready to do his presentation. Hideki, can you hear us?
Yes, sorry, I was on mute. Thank you very much, Mr. Chairman. I'm sorry I was not able to unmute myself. Now I got it. So, hello everyone. It's my great pleasure and honor to speak today. You heard from Hamza about the entire picture of our UNIDROIT project on digital assets and private law, and what we have been doing and what we have been working on so far toward making up our draft principles. So Hamza's presentation and mine may be a bit overlapping, but I'd like to talk about how the core notion in our principles, that is the notion of control, would work in three major areas that our principles cover, namely outright transfer, secure transactions, and custody. And also I would like to mention two issues that may be of interest to you today. They are a priority among secure creditors and the rule of PIL, private international law. So next slide, please. Could you perhaps, yeah, right. Thank you very much. Before I talk about the notion of control and how it works, I must say two fundamental matters about our principles. First point, we deal with private law issues regarding digital assets. In other words, we do not deal with public regulation at our UNILAW project. Second point, our principles are not intended to cover all private law issues in a comprehensive way. Rather, our principles are intended to adapt principles on core issues, intended to offer principles on core issues. And these core issues are chosen from the issues regarding proprietary rights on digital assets. The reason is that we believe those core issues are the legal issues on which people dispute, litigate, and go to court. Therefore, there is legal uncertainty existing around these issues. We believe our minimalist approach would make sense in order to give states enough flexibility in preparing their own rules in this area. As I mentioned at the outset, our principles cover three main areas: outright transfer, secure transactions, and custody. So how do we define digital assets in the first place in our project? Well, as Hamza explained, we define digital assets in our principles to be an electronic record which is capable of being subject to control. So two key words here are electronic record and control. I will focus on the notion of control. The notion of control is defined in our principle, and roughly it means a functional equivalent of a possession of a tangible thing. In most cases, you can call it exclusive control. I must emphasize that the notion of control in our principles is in the factual sense and not the legal sense. We think this is better to capture this area and provide for useful principles. So, for example, if you have the private key to a blockchain system where digital assets are held and traded, for instance, as to Bitcoin or Ethereum, and no one else has that private key, then you have control within the definition of our principle. Now, outright transfer. As slide shows, if person A transfers its digital asset to person B, then person A loses control and person B obtains control. And no one else has control of such digital asset. Next slide, please. Thank you very much. So legally, this means that assuming that person A has a proprietary right, person A transfers its proprietary right to person B. I said assuming that person A has a proprietary right. And this means that the hacker, for example, does not have a proprietary right, even if it obtains control. Now, how about secure transactions? Well, similarly, person A as the debtor can grant a security right in its digital asset to person B, the creditor. How? Well, it's easy. Person A gives control of the digital asset to person B. So person A loses control and person B obtains control. And that is enough for B's securities interest to be effective against third parties. Now, how about custody? Well, if person C has a digital asset on behalf of or for the account of person A, then C is a custodian and A is a client. In this situation, C has exclusive control of the digital asset, for example, Bitcoin or Ether, and A does not have control. But if C becomes insolvent, then the digital asset does not and should not belong to C's insolvency estate. So how can this custody relationship be created legally and should be recognized legally? Well, the answer is a contract. Such custody relationship is created by contract between C as a custodian and A as a client. Next slide, please. Thank you very much. So I'd like to address two more issues that may be of interest to you. The first issue is the ranking between two competing secure creditors who have security rights in the same digital assets. There are many other issues relating to security rights in the project, but I have to limit my talk to this issue. So as I mentioned before, generally speaking, giving control by the debtor to the creditor is sufficient for the security right to be effective against third parties. However, our principles do not exclude other methods that would make a security right in a digital asset effective against third parties. So, for example, you can grant a security right under a registration system if and where such system is recognized. Then the question arises, which creditor would get priority between the following two secured creditors? One is a creditor who filed a registration for a digital asset as collateral, and the other is another creditor who obtained control of the same digital asset. Well, our principle takes the point that irrespective of the timing of filing registration and obtaining control, the latter gets priority to the former. So in priority contest, troll beats registration. The second issue is PIL, private international law. We provide for a principle of private international law. Our proposal offers a somewhat novel approach. That is to say, we try to give incentives to the relevant parties to specify the applicable law on the digital asset itself or on the system or the platform. Today, this is not the case in existing practice. So that's why I said we try to give incentives to the relevant parties to explicitly specify the applicable law on the digital asset itself or the relevant system or the platform. Our intention, of course, is to remove legal uncertainty in this area. And we propose that if the applicable law is not determined by the digital asset itself or the system or the platform, then the applicable law is our principles. I stop here and thank you very much.
Thank you, Hideki. I've been with this notion of control for about 10 years, and I still don't know what control is. Because if I pass this over to Joseph, you see in person you're transferring possession. But it's a very difficult concept of that we need to actually capture in the understanding of digital assets. But it is also, I mean, we're talking to legal experts, so you should all know. But from my perspective, even with the 10 years of experience in this field, I still don't get a clear understanding of what control and transfer of control would look like. But hopefully your presentations actually clarified some of the basic principles that the Digital Assets Project at UNIDRAW is working on towards. I have a few questions that we have received in the chat. If there are any questions in the floor, I'm not sure if we can take them, but I'd like to actually ask these questions to the speakers first, and then hopefully get their inputs on that. The first, the development of digital assets would develop a lot faster than the formulation of rules and regulations. How could a government work out a practical timetable for a regulatory framework when things in the digital assets are so dynamic and versatile? So I think that's a question for Joseph. The second question, when legal principles for digital assets are still being developed, how can individuals and businesses adequately protect their interest over digital assets? I think this is not addressed in the Digital Assets Project, but maybe this is a question to Hideki and Hamza. And the third question is, advancement of technology seems to give a lot of possibilities. How can legal principles and regulatory regimes for digital assets being developed ensure that they can be technology neutral and cover future developments in the digital economy? And I would pose this question to both Hamza and Hideki. Another question that I do have to Joseph is, there are regulatory approaches to digital assets, and I would like to hear your views on the coordinations that might be necessary among different regulatory authorities in different jurisdictions over these digital assets, and what kind of efforts are being made to that front. So with those three questions, I'd like to pass the floor first to maybe Hamza, and then to Joseph, and then to Hideki to answer these questions that have been received. And please feel free to pose your questions on the Zoom platform, which I am able to actually access. So Hamza, first, any responses?
Yeah, thank you very much for sharing those questions, Jay. I know you only welcomed comments on questions 2 and 3 from my side, but please allow me to also give a brief comment on question 1, which I think is a fundamental importance. At UNIDWA, we, from the very beginning, recognize that there is no real practicality in running after or chasing the technology. I think my Secretary General put it really nicely a few years ago when he described the technology as a train and regulation as already having missed it. So the idea isn't to catch up to the technology. The idea is to develop a set of functional principles that are technology neutral, that put in place the legal playing ground or give consumers and participants and stakeholders in the industry the rights and certainties that are necessary and important to partake in these transactions and in the digital economy in the economy of digital assets. So, and the UNIDWA principles very, very carefully and importantly prioritize that, which is that the principles are completely technology neutral and technology agnostic in their entirety. And even when referring to real world examples, clearly point out almost every time that this is just for example's sake rather than for the purpose of being limited to particular technology. I think for question 2, with regard to how consumers and participants can protect themselves at the present, obviously, you know, as Professor Kanda very clearly noted and was recognized, the UNIDWA principles don't provide for regulation, but rather provide guidance to legislators and policymakers on how or what some of the basic ground rules are that they should think about incorporating within their domestic legislations on digital assets. And we do think that as these legislations start to develop more and more, consumers will feel better protected and safer. At the present moment, if you're in a jurisdiction with a limited amount of rules on, you know, whether you own your digital asset, what the process of, you know, creating a security right in a digital asset is, things like that. My personal recommendation would be to very carefully read the fine print and the principle of not your private keys, not your digital assets should always be applied. And I think for the third question, I think if I understood correctly, focused a lot on the value of international cooperation and collaboration. And UNIDWA certainly prioritizes that in its project on digital assets and private law, whereby it's perhaps one, the biggest working group that we're running right now in terms of the number of observers involved, which come from all sectors of the digital economy, from, you know, international development banks, international organizations, to private companies and associations of practitioners. But at the same time, UNIDWA is also, as I described, running a steering committee for the project, which welcomes input from numerous governments and jurisdictions from around the world on the digital assets project and the principles being developed. And then, as I noted, we intend to run an industry consultation early next year to really make sure that the principles that we're developing correspond to the needs of the industry. So I'll stop there, and then I'm sure Professor Kanda can add additional value to that. Thank you.
Thank you. Then maybe let's go to Joseph to address the questions with regard to most of the government's responses and possible coordinations of the regulatory authorities.
Thank you, Jay. I think both question number 1 and number 4 are very related indeed, because when you look at the development of crypto or virtual assets, right, it's a global phenomenon, it's evolving very quickly. So I don't think a single jurisdiction or government could handle along without international cooperation. Of course, Hong Kong, being a member of the international community, we also participate in different global platforms or networks in terms of coming up with the most updated regulations on virtual assets. If I may share with you, like, for example, just last month, Financial Stability Board, they just published their proposed framework for the international regulation of crypto assets activities. And just earlier this year in July, IOSCO, right, the International Organization of Securities Commissions, which actually the CEO of Hong Kong SFC is the chairman, right, of that IOSCO. In July, they also published the crypto asset roadmap for 2022 to 23. So you can see that all these international organizations, in terms of regulators or central banks or so, they update their guidelines or roadmap like very frequently, right? These two just published their latest reports like a few months ago. So I think from Hong Kong, China, of course, we continue to work on these international platforms to promote the right, the balance regulations while virtual assets continue to develop. And in fact, when we make our local legislative proposal, such as the virtual assets licensing regime that are currently under scrutiny by LASCO, and hopefully we can get the regime in place next year, is also make reference to the updated guideline for a risk-based approach to virtual asset and virtual asset service providers published by Financial Action Task Force, FATF, last year. So I will see that internationally, all these regulators and international forum will continue to work closely together to ensure the global regulatory framework in different jurisdictions can catch up with the development of virtual assets. Thank you.
Thank you. I think catching up with the developments in technology and the use of digital assets is one thing, but we also need to actually bear in mind what the questions has posed, that we need to actually be not over-regulating and also allow for future developments to take place. And I think this should be the basis of any regulatory framework that is to be developed. Now, I'll pass the floor to Hideki, but in addition to the questions that I have posed, I would like to ask you a question. As you're the chair of the group, working group on digital assets and private law, international law at UNIDROIT, what is the most difficult aspect that you actually face in actually considering the issues of digital assets, and how are you overcoming that as you chair the working group?
Thank you very much. So I would like to say something about the three questions first, and Hamza already gave us a very nice answer, so I'll try to say from a slightly different perspective. So the first question, the neutrality on technology. So we UNIDROIT try to show as many examples and use cases as possible to make our draft principles to be readable to potential readers. So for example, Jay, you asked us the question of control. Well, so for example, in the real examples, if you do have the private key, and no one else has private key, then you have control. What happens if multi-signature arrangement is found, and so forth, in the context of, let's say, a Bitcoin or Ethereum, and also in the context of the digital assets linked to other assets, and so forth. So we try to make as many examples of use cases as possible in our commentary in the principle. As to the second question, how parties should get protected, from my perspective, I would like to say many people indeed in this industry say we do not need any law or regulation because we protect ourselves by technology. So the system of blockchain or other systems protect ourselves. So there is no need for us to resort to the law. However, in reality, people litigate and go to court, and there is legal uncertainty. And judges and lawyers are uncertain about what the law, existing law is in this area. That's why we UNIDROIT try to give principles and try to reduce legal uncertainty in the private law area. Of course, those parties under these circumstances should be aware of law, including private law and public regulation. As to the third point of the global discussion, I think global discussion is very important. And But the starting fundamental problem we have is the market and parties are global, but law may be local. So the international discussion is very important, both in the area of public regulation as well as private laws. So to your last question, Jay, well, it's a very good question. And I have to confess that the most difficult issues moved and changed over the past 2-3 years. In the first set of discussion, the most difficult issue, the definition of the digital asset and also the scope of our project, whether we should limit our scope to the so-called native digital asset, non-linking digital asset, or whether we should cover the digital assets that are linked to other assets. But we finally, now we are in the process of finalizing draft principles. And what it seems to me as to the definition of digital asset in the first place, we limit our definition of the digital asset to the situation where the particular digital asset is capable of being subject to control. So the control or exclusive control notion is very important. And then on the other hand, we decided not to, our principles to not to cover the link itself or the link to a target assets. That should be relegated to what we call other law, that is the law of the state, where our principles do not cover. Excuse me. And then I would say maybe starting about a year ago or so, the most difficult issue is PIL, the private international law rules, because we talk about proprietary issues, the traditional people, of course, tend to look at the location of something. But when it comes to these assets, as you can see, there is no location. It's very difficult to determine the location. Then people might say, well, in that case, how about looking at focusing on the location of our data, or location of the grantor, for example, in the context of secure transactions, that might be fine. But right now, we are thinking about, well, maybe the best way to reduce legal uncertainty should be to specify the applicable law on the digital asset itself. And of course, that's not the case in the current practice. But why don't we try to give incentives to parties to do that? That would certainly reduce legal uncertainty. Nevertheless, what if the applicable law is not specified on the digital asset itself or the relevant system? So, well, should we look at the location of a grantor or transferor? Well, we thought that we should propose that. In that case, why don't we apply our principles? That is to say, the applicable law should be our principles. Of course, for those matters that are not covered, our principles, then I think the applicable law is to be determined by the PIA rule at the forum state. However, I have to confess that this is still being discussed, and that is probably, to me, the most difficult issue at this moment in time. Maybe Hamza, as Secretariat, have a different impression on what issue is the most difficult issue in a project, but that's my quick answers to your question. Thank you very much.
Thank you, Hideki. I was actually going to ask the questions about the applicable law issues, particularly in the context that digital assets do not exist in presence. Some of the party transactions, actually, parties might not be actually identified. They might be anonymous. So these applicable law issues is a very complicated one, and that one we will need to tackle. I think the panel has highlighted that there is a very wide range of digital assets currently being used. The development of technology has actually allowed and has requested the legal community to respond and to provide a legal framework, also to provide a regulatory framework to also ensure trust in the services. And as I was kind of hinting at, I think what the international organizations like UNCITRAL, UNIDRAW, and Hague Conference has to do is to come up with some basic ideas and basic notions which would actually educate and also be kind of allow the different jurisdictions to understand the same concepts in the same manner. And as Hideki mentioned, I think coming up with legal principles which contain legal ideas is one thing. But in order to gain the trust of the users who are going to be using transactions or doing transactions using virtual assets, they need to be trained and kind of understand it in a very easy manner. And I think the examples that Hideki mentioned as being part of the basic principles that Unidra is developing is going to actually add value in the sense that businesses would then be able to use them and be kind of more have confidence in the transactions that they're going to be engaged in. I think I promised the organizers that we'll be ending in about 2 minutes. So if the speakers have any last remarks that they want to make in 30 seconds, I would like to first give the floor to Hamza, and then to Joseph, and then Hideki. Hamza?
Thank you very much, Jay, and just thanks a lot to all the organizers of Legal Week Hong Kong for putting together this summit. And I think focusing on digital assets and the digital economy in general as part of this panel is critically important, especially given the amount of value and transactions taking place in these types of assets all around the world at all times. And I think at Unidwa, our goal is exactly what you suggested just now, which is to offer stakeholders the principles, the legal principles and the groundwork for what to base their legislation on and what to base their rules on, and then allow for greater certainty and security to be offered within the industry, and allow more stakeholders to participate in more cross-border transactions to take place. So we're very happy to have been leading this project, and really do invite everyone in the room and others to engage with us and ask questions if you have any, but contribute to the project, particularly when the industry consultation opens up next year, and to get in touch if you need anything else. Thank you.
Thank you. Joseph, any last comments? Yes.
Thank you. Well, I think if I might use the analogy of some long time ago when we first have fax machines or emails, right? They were very new to us. So similar to development and adoption of other technologies that came before, I think pathway to the development of virtual assets definitely would not be straightforward, and it involves considerable risks and to us certain uncharted waters per se. But as long as we adopt, I think, a same activity, same risk, same regulation principle, and make sure the guardrails are put in place timely, the necessary guardrails are put in place timely, I do think that we can balance the development of fintech or virtual assets and also managing the risk to ensure virtual asset business can thrive in a sustainable and responsible manner.
Thank you. Hideki, last comment.
Thank you very much, Jay. Yeah, thank you very much. I believe that the society makes progress by discussion among people. Therefore, I would like to ask you to say, please stay in touch and keep discussion. Thank you very much.
Thank you. As I represent UNCITRAL, I just need to mention that digital assets is only one part of the digital economy. There are other legal issues, and UNCITRAL is also, as I mentioned, looking into AI, data transactions, and other legal issues. And as Hideki mentioned, I think what we need to do is to continue the discussions on what kind of legal framework is necessary in order to enable transactions on these as the digital economy develops. And I would like to ask our participants to join me in thanking the speakers for the useful and informative presentations that they gave on the Digital Assets Project. Please, thank you.
Thank you. Thank you so much, and definitely also big round of applause to our moderator, Mr. Lee. So now I would like to invite Mr. Lee, Mr. Hamsin, Mr. Chan, and Professor Kanda. Maybe let's our speaker, Mr. Lee and Mr. Chan, stand up and proceed to center stage. Yes, our center stage will be perfect. Yes, and Mr. Hamsin and Professor Kanda, just look into the camera, yes. And we will have a group photo together on site here at the venue. Thank you so much. Once again, big round of applause to our moderator and our speakers for such an insightful panel discussions of today. Thank you so much, and please be seated. So ladies and gentlemen, distinguished guests, and all our physical attendees as well as our online participants, thank you so much for your support of the summit, and the morning section ends here. Please be reminded to take your personal belongings with you. I would like to remind participants our afternoon section will resume at 2 p.m. and we will now have the lunch section. And for speakers, moderators, and invited guests with an orange dot on your name badge, please kindly proceed to lunch in rooms N206 to N208, which is just right opposite to this conference hall. And the summit will resume again at 2 p.m. So please kindly return to this venue 5 minutes before our resume time, which is 2 p.m. so we can start on time and enjoy our upcoming 2 panel discussions of this afternoon. So ladies and gentlemen, have a wonderful lunch and see you back then. Thank you. Ladies and gentlemen, distinguished guests, just a gentle reminder, during our lunch break, please do remember to take all your personal belongings with you while you're having lunch. Yes, because we just want to ensure all the valuables are with you, but not staying inside at this hall, okay? Thank you so much.